to your Lordship,
Thank
my Lord,
you.
for being appointed as a permanent judge of this chartered court. As also, I wish, my Lord, from this side also.
Thank you, Mr. Datta.
All of us, my Lord, I'm extending my warmest, my Lord, greetings and wishes for your Lordship's memorable judicial career, my Lord.
Thank you. Thank you, Mr. Agarwal.
All.
From the bar.
I am taking leave of my learned senior, Mr. Dotto.
No, Datta also said. Mr. Datta also said.
No.
May I have your Lordship's kind leave to mention, my Lord, due to my Lord, demise of my mother, my Lord, last week, my Lord, I could not attend, my Lord. My Lord, this matters were called, my Lord, and my Lord, it has all the both the matters have been posted on 14th May, my Lord. This is contempt matter, my Lord, and I am led by Mr. Agarwal, my Lord, and he will be leaving, my Lord, on 7th for years. So, my Lord, kindly keep it tomorrow, my Lord, as to
Which matter?
My Lord, this contempt matters, my Lord.
Tell me the names.
Shonai.
Okay,
Shonai
okay,
Food
okay.
Marketing.
So,
I could let it appear tomorrow as to be mentioned, my Lord.
tomorrow.
Tomorrow. Contempt matters.
Which for the state?
My Lord, state is, my Lord, I shall inform.
So they have filed one application that was turned down.
That was turned down, my
They
Lord.
have
I
preferred one
have given the
appeal.
notice, my Lord.
No, they have
Amritalal Chatterjee.
No, they have submitted and preferred an appeal
My Lord,
against the order.
but my Lord, my contempt petition is there, my Lord. When contempt is there, my Lord, contempt can be heard,
I
my Lord.
understand. Mr. Chatterjee was there.
Yes, my Lord. Amritalal Chatterjee, and I have given notice has been served.
Nilotpal Chatterjee was there.
Amritalal Chatterjee and maybe Nilotpal Chatterjee is leading
there.
Leading.
He said the state will prefer an appeal. That's why the date was fixed on 14th of May.
But my Lord, they have not yet served us a copy, my Lord, of the appeal, my Lord. And my Lord, contempt petition, my Lord, anyway, my Lord, that cannot be a bar, my Lord, for moving.
No, I know.
They have not taken any steps, my Lord. So my Lord, let the matters appear tomorrow, my Lord. I shall inform again, my Lord, that tomorrow.
You inform them first.
My Lord, I have given notice, my Lord. Notice have been served, my Lord.
Okay.
My Lord, with notice, my Lord,
Tomorrow
I mentioned. Tomorrow to be mentioned, my Lord. Both
tomorrow to be mentioned.
I'm great.
Old matter hearing.
Old matter?
Hearing.
For what? Group 1 or group 8?
But this is hand matter acquisition.
Group 1. Group 1. Okay.
May I have my Lord's kindly to mention item number 100 of today's list. Let the matter appear tomorrow as mentioned matter. What happened, my Lord? I am covered by your Lordship, affirmed by the Honorable Division Bench to that effect that my all 100, item number 100 of today's list.
100.
100, let the matter appear tomorrow as to be mentioned matter, my Lord.
New motion matter.
New motion matter. Let the matter appear tomorrow as mentioned matter.
Item number 100, tomorrow mention matters. Item number 100.
Lord, I may be permitted to make a mention. I am from Andaman.
Yes, I know you are from Andaman.
There is
Why you are here?
There is a fresh matter which I have to move because day after is the date fixed for my eviction. They have Tasla passed an order. But I want to leave so that I can move this matter after the lunch.
So I have only group 1 and group 8.
Group 1 land matter.
Group 1 land matters, not new matters I have assigned. I have assigned only till 2022. You have to mention before a bench having determination of new matters.
New matters.
Yes. I have only determination till 22. How are you?
I'm fine.
Okay, very good.
Congratulations.
My lord, may I be permitted to mention a matter? This is for extension of interim orders, my lord. The urgency.
On matters.
Group 1 matters, my lord. This is
Lordship,
for extension of interim.
Lordship, may I be permitted to mention a matter for inclusion? This is a Group 1 matter of 2021. Grateful, Lordship.
Call the list.
I appear for the state respondents.
That 5 minute I appear for the petitioner. My lord, I'll be humbly beseeching your Lordship to take up the matter tomorrow, my lord. My file hasn't come. My lord, I've already informed my senior friend, my lord.
What is the matter about?
Well, notification matter, my lord.
Okay,
But
okay, okay.
so kindly
So
take
Can
you supposed to
notification?
correct the name of like that.
that has been done, my lord.
You have done.
That has been-
No, my lord, he is
privacy is
saying
also there.
accommodation, my lord, I cannot, I normally stand, I don't stand in the way. But my lord,
Okay, come on
this is
tomorrow then, Mr.
Tomorrow,
Dotto.
tomorrow.
very,
Come on tomorrow. Mr. Shubhankar Das was there. Where is he?
Just here.
Yes, you are just here.
I just check it. Well, they are here.
Mr. Huda is going to search you.
Mr. Sir.
Tribal me extension. There's a detection for filing affidavits. No affidavit has been filed. Or filed. The interim order is going to be expired.
ऑर्डर का डेट बोलो
25/3/25
Miss Sina, where is the report?
Yes, your lordship, I do not know my learned junior also who is assisting me. I cannot see her. I will inquire and I will.
Okay. Please take down.
No.
This matter appears under the mentioned matters. Full stop. Mr. Devabrata Sara, learned senior counsel appearing on behalf of the petitioner submits that interim order passed by this court on 25th of March 2025
But this is a
It's going
vacancy
to-
matter.
Yes, yes.
is going to expire on 30th of April 2025. So he prayed for extension of interim order. It appears that the state respondent supposed to file a short report today. However, Miss Sonal Sinha, learned counsel appearing on behalf of the state respondent submits that the report is not ready. So he prayed for some accommodation. Considering the submission, the time for filing the short report is hereby extended till further a fortnight. Full stop. Considering the entire aspects,
The vacancy matter in
interim-
other matters, your lordship directed to go out of list because the appeal is being heard by the division bench. Today is also fixed.
yes, what do you suggest?
After report there is.
Report. Actually, my learned friend is not wrong. If this matter is decided, then hardly there is any scope.
Very good. Having heard the learned counsel for the parties, let the interim order passed by this court be extended till further order. Let the matter go out of the list. Parties are at liberty to mention.
I'm grateful.
And lordship, heartiest congratulations.
Thank you, Ms.
From the bar,
Yes.
for all of.
From
And today's program was also nice. Today's program was also nice.
Thank you.
grateful.
Please call the list.
Item number 7, Lordship, I beg to appear on behalf of the petitioner, Lordship. Lordship, in earlier occasion, the state respondent has appeared. 7 and 8.
Why it is appearing under mentioned matters?
My lord, Mr. Nirodpal sir.
7, my lord, I am for the state.
This matter, the point of maintainability like that.
My lord, the first,
How many matters are there?
my lord, the same points, my lord, Mr. Kengutu was also
Which matter?
arguing.
Which matter?
Similar points, my lord, of locus.
Yes, look.
I cannot additional point.
No, item number.
There are series of matter and follow this.
In my matter, Lordship, the petitioner who have
7.
item number 7. I am for the petition, Lordship. In my matter, item number 7, in earlier occasion, the state respondent had raised the question that whether a petitioner who filed that application can be eligible to file this application when he running a shop under a partnership firm. That was
Unregistered
question.
partnership firm.
So it is a different point.
Yes. So this point, so far
Right.
this point is concerned, my learned friend who appeared on behalf of the state has cited one order judgment passed by a division bench of this Honorable High Court Lordship, that is MAT 252 of 2025. But after gone through the judgment Lordship, what I am find that the subject matter of this MAT application is totally different. So my matter is that Lordship, there is no question of that the other partner who have raised any objection for filing of the application is not, that will be the question. I don't make him a pro forma respondent in my matter. So the petitioner, who is a partnership firm running the FPS shop under a partnership firm Lordship, and he is praying for a relief, as the single bench and division bench has held in several cases that whether the vacancy notification has been issued in terms of the control order 2013 is valid or not, which is still pending
No,
before the
let them,
Honorable
let
Division
them,
Bench.
let me hear them.
So now so far the question of maintainability is concerned, Lordship, I can only praise before your Lordship that there is no question that there is any objection from the other partner to make this writ application before your Lordship. And
let
the
them submit
operative
first.
portion of the order which has been cited, Lordship, that is totally different.
No, let them submit first.
আগে নাকি দিয়েছিল না কোনো judgment? Not may I rely?
Yes.
Paragraph 10. This is MET number 2. And firstly, there is a twofold maintainability. The first point of maintainability is the point under the Partnership Act. And the second is Lordship on those batch of matters which Mr. Sengupta would be arguing that whether my learned friend has any locus standi or any legal right to challenge an order of detagging, which kindly let Mr. Sengupta to argue. He's arguing the
No, you are arguing on the point of
maintainability. This is initially the first point of maintainability is under the Partnership Act, Section 28 of the Partnership Act.
As a whole, Miller, apart from this point, as a whole, whether the person
control order.
I will argue on that. Whether it's been aggrieved, person aggrieved or not, that has to be argued by me.
aggrieved means aggrieved against the decision of the state.
Detag.
Decision regarding detogging.
Detag.
Okay, what you are?
Person aggrieved or not.
Yes, you proceed.
Yes. But kindly takes this judgment, paragraph 10 onwards, Your Lordship.
Yes.
Section 68 of the Partnership Act mandates that any dispute before a court of law or otherwise by or against the registered partnership firm is required to be filed only in the name of such firm. The firm can, by resolution, authorize any individual partner to pursue, file, and assign pleadings in such proceeding. Strangely, none of the proceedings since 2006 referred to by learned senior advocate Mr. Shahare and Mr. Nilapal Chatterjee for the state bear the name of the firm having filed or taken out in the name of the firm. None of the petitions, therefore, including WPA number such and such, wherein the impugned order has been passed, indicate that they were taken out by and or in the name of the registered partnership firm. The situation is further compounded by reason of the private respondent intervener who claims to be a partner of the firm in whose name the license for MR distributorship has been issued by the respondent authorities has vehemently opposed the locus standi of the petitioner. It is submitted by Mr. Shahare, learned senior advocate appearing on behalf of the respondent, that there is a suit pending as regards the dispute between the partners of the licensee. In view of the above, the locus of the petitioner respondent to maintain the writ petitioner or any proceeding by describing herself as carrying on business in the name and style of such and such is fraudulent and expressly illegal. Such descriptions are made only in respect of proprietorship or unregistered partnership. In the latter case, the petitioner is required to mention the name of all the partners and implead them as pro forma respondents or petitioner, or indicate due authorization by them to take out and maintain the said proceedings. This alone is a ground for rejection of WPA number such and such. Paragraph 16, Your Lordship, be that as it may, the learned single judge, in the opinion of this court, has committed error even on merit. This, my lord, goes on the merits. This perhaps, my lord, stays my learned friend in his face. That I will just indicate from the cause title. I'll give him a copy. Sorry. Your Lordship will kindly see one petitioner is before your lordship and kindly comes to the affidavit page. Only one Mr. Shankar Pal is before your lordship,
Is the petitioner.
is the petitioner. And there is no pleading as to that effect, as to on what authority, whether it is at all been authorized by the partnership firm to institute this writ petition. Kindly see the affidavit page is at page 37.
Now, whether the petitioner is one of the member of the partnership?
Yes, yes. My lord, kindly sees the license, which is at page 38. My lord, clause 1. Kindly see who has the license been granted to. Messrs. Manmohini Paul and Sons. So the firm is not before your lordship. Even for argument's sake, I assume, I do not know if the firm is registered or not, because there is no pleading to that effect. Even assuming the firm, I will not interrupt you when you're submitting. So assuming that even if it's an unregistered firm, the other partners are not before your lordship. And kindly see how he has verified, as if it's his individual license. The license is not his individual license. When the partnership firm may not be a juristic entity, it may be a compendium of the partners, but the license is in the name of the partnership firm. But the deepest of respect, perhaps this writ petition in this form is not maintainable. Kindly cease. I do not even know who are the other partners.
Also, affidavit portion, he has not said that.
Not said that he's authorized on behalf of the partnership firm, or whether who are the other partners. Kindly see, I am the present petitioner here, and as such, I am well acquainted. So he's filed it in his individual capacity. My learned friend will indicate whether his firm is registered or not. That is the first point, because no partnership document has also been annexed to this. But if your lordship holds in my favor, perhaps I need not argue the next point of maintainability, that he has no legal right either.
Can I come to paragraph number 3?
Paragraph 3
of my writ application. That is a pleading lordship that your petitioner states that your petitioner has been running the FPS dealer business run by the petitioner and his father under the name and style of Messrs. Manmohan and Sons, being FPS number such and such with an unblemished track record and with full satisfaction of all concerned, include the satisfaction of the officials of the FPS department and the tagged ration card holders, and no complaint allegation has been raised against your petitioner with regard to running of the said dealership business. I have mentioned, lordship. It has been
But where is
specifically
your
mentioned.
authority to file the writ?
Lordship, so far the order is concerned, which my learned friend is relying, lordship, that is in another aspect. That one
Now,
pro forma
forget about the
intervener
order.
who come up.
Where is your authority to file the case?
Lordship, I am one
on
of the
behalf
partner.
firm?
I am one of the partner, lordship. If
Now,
lordship
have you,
desire, I will
have you
come.
stated in your affidavit that I am?
Lordship, so far the affidavit is one of the ordinary practice which we are followed, lordship.
No,
that
no,
when we
not
file
ordinary
the
practice.
petition, the petitioner is the sole petitioner is there, lordship. He filing this affidavit, lordship.
I can allow
If
you
there
to file afresh.
Yes.
that can be, lordship. If that can, lordship, I can.
Okay.
Yes.
Please take down.
But then, lordship, that only this indication, lordship, to withdraw and file a fresh. Liberty to
Yes,
file a
yes,
fresh.
liberty to sue afresh. Having heard the learned counsel for the parties, it appears to me that the instant writ petition cannot be continued further. Accordingly, the petitioner is a leave to sue afresh. Sue afresh on the self-same issues. Under the above observation, the instant writ petition disposed of.
Lordship, liberty given to file a
Liberty
fresh.
to sue afresh
Grateful.
on the self-same issue.
Lordship, may it be uploaded by today itself, that I will be able to file by
Today.
tomorrow.
Let me see.
May I please your lordship, my lord?
Yes.
My lord, this matter I am challenging. I am challenging the vacancy notification, my lord. For the reason, your lordship will kindly come to paragraph 5, my lord, at page 3.
পেন্টেন কিছু নেই
what
But-
is the
but-
point of maintainability raised by them?
Then my lord, let him, let
Yes,
us
let them
Let us place-
submit first.
Yes.
Yes.
I place my reliance first on a judgment passed by Honorable Justice Vivek Chaudhary.
Yes, what is the issue here? What is the,
He has raised a vacancy point, Lordship, though I have also received separate instructions, but what I could see that exactly same thing which has been put in the instruction form is a part of the judgment here. I would like,
part of this
yes,
judgment?
yes, I have handed over a copy. Kindly start from page number 3 onwards of the judgment.
Yes.
My instructions are exactly similar. I will not take the trouble of placing both simultaneously. I will just rely on the judgment. Government in Food and Supplies Department is aware of the fact that the ration card population attached to the existing fair price shops running in the districts is not evenly distributed. Some shops are quite overpopulated of various degrees, whereas some shops are running with much less population. Naturally, both the beneficiaries and dealers are being adversely affected in terms of services through PDS and business volume, which is proportional to the tagged ration card population. In view of the said situation, rationalization of existing ration card population of the fair price shops of the state has been under active consideration of the department for quite some time in the past, and the government has decided to rationalize ration card population registered with the existing FPS through setting up of new FPS or merger of ration cards with neighboring FPS as may be convenient to the concerned beneficiaries for better service to the beneficiaries through PDS and bringing in a rational level of parity in terms of volume of business among the shops. It is to be kept in mind that in exercise, a certain range of ration card population between 6,500 to 7,500 considered to be the minimum average has to be kept retained with the existing FPS while exploring rationalization proposals subject to the geographical locations of the areas and convenience of the beneficiaries. However, a new FPS may start with a minimum average population between 4,000 to 5,000 beneficiary cards. It has to be kept in mind that all categories of ration cards of the habitation and full family shall be tagged or shifted. Now, following points are meant for guidance. Now, all the situations have been mentioned. I will just very cursorily, I will just place my points. The following situations may occur while considering the rationalization proposals. Situation 1. In case of FPS, overpopulated FPS having card population more than 12,000, proposals for new vacancies may be given at appropriate locations of the areas under the service of the existing FPS through bifurcation of the card population as may be convenient for the concerned beneficiaries. Situation 2. In case of overpopulated FPS having card population between the first one is more than 12,000, then it is 10,000 to 12,000, around 3,000 to 5,000 cards of the existing FPS may be considered for detagging and to be clubbed with the detagging overpopulated card of any neighboring FPS for declaration of suitable new vacancy. The proposal of the same may be given at locations as may be convenient for the concerned beneficiaries. The order of 11/2/2022, number 328 of this reads as follows. Food and Supplies Department has issued guidelines, Bide Memo number 3004, FS dated 21 vacancies or merger of small ration card population with the neighboring FPS. In the said guidelines, it was envisaged that in case of excess population, a range between 6,500 7,500 ration card beneficiaries has to be retained with an existing FPS while exploring such rationalization. However, necessity for further modification of the above range of retained population was felt and under active consideration of the department of or sometime past, now it has been decided by the department that a range of 5,000 to 6,500 ration cards will be considered as the average population
to be retained with an existing FPS. However, a new FPS may start within a range of 3,000 to 4,500 ration card population. The vacancy order of 20, each vacancy order has been dealt with, and number of FPS also has been declared. After finishing, concluding with this, I will come to Mr. Agrawal's petition as to what are the prayers and how does the judgment applies on it. The vacancy order of 28/3/2020. Yeah, yes. Guidelines for rationalization of excess ration card population of through declaration of new through declaration of new vacancies or merger of small ration card population with neighboring FPS were issued by the department Vide 3004 FS dated 3/9/2021. In the said guidelines, in case of shops having excess population, it was envisaged that 6,000 to 6,500 to 7,500 ration cards were to be retained with an existing FPS for declaring a new vacancy. Later, the above range of retained population was modified to 5,000 to 6,500. A new vacancy was to be proposed with a range of DRC population of 3,000 to 4,500, BD number 328, FMR dated the 11/2/22. However, certain issues have been raised from some quarters regarding the retained population and proposed population for a new vacancy, which were under active consideration of the department. Now, after due consideration of the matter, it has been decided that for the purpose of proper and complete rationalization of existing ration card population for ensuring better service to file concerned beneficiaries through PDS, a new vacancy may be proposed with the population which may be less than 3,000 and DRC population retained with an existing FPS may be less than 5,000. Considering local scenario, convenience, inconvenience of the beneficiaries and in the larger interest of the PDS in the locality. Therefore, from the above orders, it can be inferred that via the notification of 2021, the minimum average ration card population that had to be kept retained with the existing FPS dealers was fixed at 6,500 to 7,500. According to the order of 2022, the minimum average ration card population that had to be kept retained with the existing FPS dealers was fixed at 5,000 to 6,500. Now, according to the vacancy notification of 2023, the FPS dealers would be allowed to retain less than 5,000 ration cards holding population considering the local scenario, convenience, inconvenience of the beneficiaries, and the larger interest of PDS in the locality. The petitioner is an existing FPS dealer. He states that a total of 7535 number of consumers ration card holders are presently tagged with his dealership. Therefore, if any appointment is made by following the vacancy notification, then in that event, the number of ration cards tagged with the petitioner's dealership would be drastically reduced from 7535 ration cards, which would be less than the viable limit. Therefore, the said vacancy is notice is liable to be set aside or cancelled. The petitioner argues that the said business of MRFPS dealership is the only source of petitioner's life and livelihood, which is guaranteed under Article 21 of the Constitution of India. He has invested huge sum of money in carrying on the said dealership business, and therefore, if the vacancy is filled up in terms of the said vacancy notice, ঠিক আছে হ্যাঁ পরে তারা এটি তো পড়ছি and curtail the ration cards tagged with the petitioners. This is ঠিক আছে dealership. Then in that event, the petitioner will irreparable loss and injury, which cannot be compensated in other way as the viability of his business would be greatly affected. He argues the respondent issued impugned notification without following the provisions of the control order and existing policy norms and procedure for the appointment of a new dealer. Therefore, the said notification is not tenable in the eyes of the law, and this is a glaring example. This is what his petition is all about, of an arbitrary exercise of power. He contends that he is carrying on business strictly by following the Control Order 2013 and distributing the MR articles of the consumers tagged with his shop as per allocation made by the competent authority from time to time. None of the consumers tagged with the petitioner's business raised any objections either to the petitioner or to the competent authority that they are not getting MR articles as per the allocation made by the competent authority or facing difficulties to get the said articles and or the petitioner is not functioning properly. Therefore, the impugned notification of vacancy was published without any basis, and for this reason, the petitioner is praying before this court to issue a writ of mandamus commanding the respondent to cancel, resign, and to set aside the vacancy. After hearing the arguments of the learned counsel at length, it is the opinion of the court that the respondents have not acted in an arbitrary manner while decreasing the rational card holding population to 5,000 for existing FPS dealers. While it is true that the petitioner would have to deal with a lesser number of population and it could lead to some financial losses, the administrative action does not violate any legal right of the petitioner. While taking out the new vacancy, new notification for the vacancy, the Department of Food and Supply Government of West Bengal acted within their power and authority delegated to them by the state government under the NFSA 2013. The primary objective and expansion of public distribution system in India is to provide necessary consumer food items at subsidized and cheap prices, protecting the consumers from increasing prices of goods. Therefore, it is in furtherance of this objective that such administrative decisions pressed about the petition, which would benefit the public at large and not just cater to the interest of a selected few. After the introduction of the targeted public distribution system, the state government has to identify eligible beneficiaries under the NFSA 2013, and these eligible beneficiaries would replace the existing set of beneficiaries and categorized under AAI below poverty line and above poverty line. As a result, these eligible beneficiaries would be tagged with the respective price shops where they would get their entitled quantity of food grains as stipulated under the Act, and therefore there would be a need for de novo tagging of eligible beneficiaries with the fair price shops, which may in turn result in the reduction in the ration cards tagged with such dealers under NFSA norms. This was published by Food and Supplies Department, Government of West Bengal, dated 12/3/15. Therefore, following these guidelines or objectives, the department issued a notification with a subsequent reduction in the number of ration card holding population of existing FPS dealers. Therefore, I find no merit in the writ petition. It is dismissed on contest. There shall be no order. After that, an appeal was preferred and that was also dismissed. Lordship, may I hand over another two judgments also? The first paragraph, it's a very small judgment. 1999, 5 SCC, 612, District Collector and others versus B. Suresh and others. The short, third paragraph. The short question that arises for consideration in this appeal is whether the respondents who were appointed as FPS dealers under the Andhra Pradesh Scheduled Commodities Regulation of Distribution by Card System Order 1973 can claim a right to be noticed when the state government decides to bifurcate the shops and reduce the number of cards. The High Court, by the impugned judgment, being of the opinion that such fair price shop dealers are to be noticed before any alteration is made, has quashed the decision of the government. The state assails the aforementioned judgment of the High Court. Under the provisions of the Andhra Pradesh Scheduled Commodities Regulation of Distribution by Card System Order 1973, which order has been framed under the provisions of the Essential Commodities Act 1955, a fair price shop dealer has no right to be appointed as such dealer. The deal with the commodities has not been cancelled. The right to trade under Article 19(1)(g) of the Constitution of India is not being affected in any manner. The government, as a policy decision, decided to reduce the number of cards per dealer. Such decision does not affect the rights, if any, to the fair price shop dealers, and as such, the High Court was in error to hold that were not to be given any notice prior to the impugned decision of the state government. So this is a very basic fundamental which our single bench has also held. High Court is also of the similar view that if the state, on the strength of certain circulars, has decided, the state only can decide what is the best thing that is to be done for smooth operation and distribution of the articles. So in these two judgments which I have placed before your lordship, these paragraph 31 of Sitara Begum also, paragraph 31, lordship has a copy. It's Arabega. Iktis, 31.
Okay, you read out.
I'll read out. Mr. Saharoy, declaration and the headline, the head note. Declaration of vacancy whether is violative of Article 19(1)(g) of the Constitution of India. This is
That is Setara Begum.
this is
Appeal order, order of appeal.
Yes.
Single bench order.
That is under appeal, my lord.
Which is
That
that
cannot-
is not. But the decision that has been taken over here, that is. ঠিক আছে, 2013 is on the chart. Mr. Saharoy, learned advocate for the above mentioned petitioners, argued that State Control Order 2013 is framed in exercise of power conferred under Central Control Order 2001 and following the terms and conditions, MR distributorship license and FP shop dealership licenses were issued under State Control Order 2013. The Central Control Order 2001 has been superseded by the TPDS Control Order 2015, which provides in paragraph 9 that the central government has delegated the power to all the state governments and union territories to issue orders. The State Control Order 2013, which has been issued in terms of Central Control Order 2001, has lost its force and had become redundant non-est since the Central Control Order 2001 has been superseded by TPDS Control Order 2015. It is legitimately expected that the Food and Supplies Department Government of West Bengal shall frame a fresh control order in terms of TPDS Control Order 2015, since State Control Order 2013 has no existence after supersession of Central Control Order 2001 of the central government by virtue of TPDS Control Order 2015. However, the Food and Supplies Department Government of West Bengal has declared vacancy of MR distributorship and FP shop dealership in terms of State Control Order 2013, which clearly is violative of the writ petitioner's right protected under Article 1(g) of the Constitution of India, since such engagement of dealers, distributors shall curtail the volume of business of the writ petitioners. It is a settled proposition of law that if the foundation goes, then the superstructure falls automatically. The foundation of State Control Order 2013 is the Central Control Order 2001. Since Central Control Order 2001 has already been superseded by TPDS Control Order 2015, the State Control Order 2013 also stands superseded, and therefore no vacancy can be declared invoking the provision of redundant State Control Order 2013. In reply to the aforesaid contention, Mr. Sirkanya Bandyopadhyay, learning junior standing counsel for the
This is issue of 2013 control. This issue not here. This issue is not here.
This is 2024, Your Lordship.
Yes, this is not issue here.
No, no.
This is not issue here.
See, you want to take it. What my learned friend is trying to apprise me, and I will subsequently advise Your Lordship that you not have legal
Take the
right.
mic properly. I cannot hear you.
I had a loud voice. I thought everyone can listen to me. That is why I'm taken aback. Let me complete because since I've started reading
No.
it.
Setara Begum is in respect of 2013 control order. Yes.
My lord, why I intended to rely on this requested my learned friend to show this judgment. If your lordship sees Setara Begum, it has been decided in Setara Begum that the petitioners did not have any, the point that my learned friend is arguing and Mr. Shengupta will also be arguing, that the petitioners did not have any legal right to initiate these proceedings because no legal right was being infringed, as has been held by the Supreme Court as well as single bench of this court. And most interestingly, in the grounds of appeal in Setara Begum, this has not been challenged by Mr. Shahara. There are categorical findings in Setara Begum relying on all these judgments. The 1995 Supreme Court that my learned friend showed, even Justice Vivek Chaudhury's judgment, they are all referred to. And ultimately,
which is being emphasized is this right is not being infringed. Article 19(1)(g) has not come into play. That is the main contention. If Lordship will directly
No, in the Supreme Court,
yes.
in the Supreme Court,
The
that is
judgment
99 5 SCC 612.
yes.
The question is whether the ration card holders, that is the licensee, has a right to hear regarding detagging.
Right.
Supreme Court says there is no such right.
Yes.
There is
That
no
is
such
what-
right with the dealer.
Yes. regarding data.
My lord, if there is no such right, no mandamus can be issued.
Can
Mandamus can only be issued if there is infringement of a right.
Yes. This is the basic question. And what are the prayers which have been raised by?
He is also saying
Is-
that 19(1)(g) is being violated in
No,
grounds.
how? This we have shown now.
Yes.
If Lordship allows, I can show the prayers also, which Mr. Agrawal's petition and this petition before your Lordship, which is there. Basic thing is that no right is being infringed. The only issue that is being argued before your Lordship is that, well, a writ petition has been filed, but he is not being affected. The judgments are only to show that he is not being affected at all. Kindly seize the prayers, page number 11.
Yes.
Culminating in the impugned prayer B. Vacancy notice 8 January 2025 issued by the Sub-Divisional Controller Havda Sadar forthwith. B. Culminating in the impugned vacancy notice dated 8th January 2025 issued by the Sub-Divisional Controller Food and Supplies Havda Sadar, so that upon perusal thereof, conscionable justice may be rendered to the petitioner by quashing the same. Impugned vacancy notice 8th 2025. D. Each of them to allow the petitioner to continue with his existing number of ration cards. E. Rule nisi in terms of prayers A, B, C and D above, and to make the rule absolute if no causes are shown. F. An interim order restraining the respondents and each of them from giving any effect or further effect to the impugned vacancy notice dated 8 January 2025 issued by the Sub-Divisional Controller Food and Supplies Havda Sadar in any manner whatsoever. Stay of operation. Add interim order in terms of prayer F and G above, costs and such other orders.
And paragraph 39 of Sitara Begum holds this. He has no right.
But still, this is under appeal.
I'll argue that matter because the division bench judgment of this it is always interested between the parties.
Yes, that is already been.
Doesn't let it.
That order, your lordship, when after in Sitara Begum, a clarification was sought that it is always in between the parties. If lordship remembers, and lordship also passed an order in a original side matter, exactly the same judgment. That clarification was relied upon, which my learned senior friend also showed at the time of review, and lordship was gracious enough to reject it. That case, that is Sujata Mitra. If lordship remembers, in the original side matter, we were there before your lordship. That and
I know that.
Yes, and subsequently state had issued the license and detagging and everything took place.
Issue between the appellants.
Yes, yes.
Not with the other persons or other.
So Article 39, paragraph 39, Article 19, 1G of the Constitution of India confers on all citizens the right to practice any profession or to carry on any occupation, trade or business. This freedom means that every citizen has the right to choose his own employment or to take up any trade or calling subject only to the limits as may be imposed by the state in the interests of the public welfare and the other grounds mentioned in Clause 6. All activities contemplated under Article 19 1G are essentially activities which enable a citizen to generate economic benefits, which is the primary purpose and thrust of the said article. The object of using four analogous and overlapping words in Article 19 1G is to make the guaranteed right as comprehensive as possible to include all the avenues and modes through which a man may earn his livelihood. The guarantee takes into folds any activity carried on by a citizen to earn his living. Trade in its wider sense includes any bargain or sale, any occupation or business carried on for subsistence or profit. It is an act of buying and selling of goods and services. Business means and includes anything which occupies the time, attention of labor of a man for the purpose of profit. It is trite law that while a citizen has a fundamental right to carry on a trade or business, he has no fundamental right to insist upon the government to have a specific number of ration cards allotted to him as a dealer or distributor. What is guaranteed by Article 19 1G is the right to pursue a calling or to carry on in occupation of one's choice, and not the right to hold a particular numbers of ration cards. Undisputedly, the licenses granted to the dealer or the distributor has not been cancelled. Therefore, the right to trade under Article 19 1G of the Constitution of India is not being affected in any manner. The government, as a policy decision, decided to declare vacancy notifications for smooth functioning of the public distribution system, which may lead to curtailment and reduction of the number of cards per dealer or distributor. However, such decision does not affect the rights, if any, of the fair price shop dealers or the distributors, and cannot be said to be infringement of any right of trade under Article 19(1)(g) of the Constitution. So this is what I'm, three judgments. One, Sitara Begum itself has been relied upon. Subsequent to this clarification sought, Lordship also has also passed order in
That is in respect of 2013
yes.
control order, not
Yes.
like
This is
that.
purely on a point of law.
This-
This is a principle.
What I'm trying to indicate before your Lordship is what has been challenged by Mr. Agrawal.
In this writ
Yes,
petition.
in this, specifically in this writ petition, why I say that it is this not maintainable on the strength of certain judgments which I have placed before your Lordship, that his right is not being affected at all. And moreover, he has argued on certain ration cards, and on the strength, the ration cards, the tagging, whatever has been done, it is to ease the operation of the state government, and his rights are not being affected at all. This is the state policy which was formulated by the state government to ease the operation, to smooth out. So this is exactly his prayers, exactly what he has tried to indicate by the prayers which he has in his writ petitions, and we have tried to counter it by way of certain judgments. And Sitara Begum also, though it might be pending before the division bench, these paragraphs, which paragraphs I have tried to bring before your Lordship, categorically says that this petitioner before your Lordship is not being affected by even the pendency of Sitara Begum in the division bench. This is what I'm trying to indicate to your Lordship, if I have made myself sufficiently clear on this. Now I would request my learned senior friend. Right. Sure.
Yes, my lord, this is not a case where I am very much harping upon 19(1)(g). The entire judgment of the Supreme Court is based, I am reading the paragraph 4 again for your Lordship, my lord. Under the provisions of the Andhra Pradesh Scheduled Commodities Regulation of Distribution by Card System Order 1973, which order has been framed under the provisions of the Essential Commodities Act. Your Lordship will kindly mark it under Council Commodities Act. This act was a fair price shop dealer has no right to be appointed as a dealer. The license which such dealer has obtained under the provision of the Act to deal with the commodities has not been cancelled. The right to trade under Article 19(1)(g) of the Constitution of India is not being affected in any manner. The government, as a policy decision, your Lordship can mark, it is a policy decision. As a policy decision, decided to reduce the number of ration cards per dealer. Such decision does not affect the rights, if any, of the fair, and as such, the High Court was in error, my lord. My lord will consider the government, as a policy decision, decided to reduce the number of ration cards. What has been decided here in the government, by the government, I shall place for your Lordship. No matter so this is not applicable in my case, my lord. I shall show that what government has decided. I am relying upon the government decision. I am not relying upon my decision or 19(1)(g). I am just relying upon the government decision. Then, my lord, kindly, your Lordship knows that minimum ration card should be 5,000. I am not disputing that. But whether that circular of 5,000 ration cards can be maintained by the director, I will argue on this matter. Moreover, my lord, the judgment of Justice Vivek Chaudhary, with great respect to my lord, has not laid down any law. And if a person does not file any appeal against that, I am entitled to make my submission otherwise, which have not been made before Justice Chaudhary. Now, my lord, kindly come to my case. My lord, I will kindly come to paragraph 5.
What paragraph?
Five.
Petition.
Yes.
My lord, the petitioner is presently catering about 3,000 ration cards of Kesapur. Your lordship kindly mark 3,000 ration cards of Kesapur, 2,500 cards of Begri, and 1,150 ration cards of Bipanpada. So I am running 6,600 ration cards. Out of his 3,000 cards are of Kesapur. If these 3,000 ration cards are detected, then I am left with only 3,600 ration cards. And your lordship knows there is a minimum viable limit is 5,000 ration cards. That is the first point, my lord. Therefore, my right is affected according to the government, according to the circular of the director. Now, my lord, I am coming to that, whether the circular of the director can be maintained. What is the policy decision, my lord? I ask myself. A state, upon consideration of so many factors, issue a policy guidelines. That is at page 23. His lordship got, my lord?
23.
23. The first page is at page 22. That is 3rd September 2021. And this is the guidelines. Number, this is the policy guidelines of 2021. Your lordship, my learned friend has already read this guideline, situations and the other. I am just reading, my lord, that the order of the director, your lordship will kindly come to page 27. Has your lordship got, my lord?
Yes.
It starts from Food and Supply Department. Food and Supply Department has issued guidelines with a memo number such and such dated 3/9/2021 for rationalization of excess ration cards population of existing FPS through declaration of new vacancies or merger of small ration card population with neighboring FPS. In the said guidelines, it was envisaged that in case of excess population, ration cards tagging 7,500 ration cards, beneficiaries has to be retagged, retained with the existing fair price stock. Now, however, necessity for further reconciliation of those range of retained. Oh, my lord, there is a type copy on next page. But I am again reading, my lord, type copy or not there. Food and Supply Department has issued guidelines via memo number 3004 FS dated 3rd September 2021 for rationalization of excess ration card population of existing FPS through declaration of new vacancies or merger of small ration card population with neighboring FPS. In the said guidelines, it was envisaged that in case of excess population, a range of 6,500 and 7,500 ration cards public beneficiaries has to be retained with all existing FPS while exploring such rationalization. However, necessity for further population of the above range of ration population was left and under active consideration of the department for some time past. Now it has been decided by the department that a range of 5,000 to 6,500 ration cards will be considered as the average population to be retained with an existing FPS. However, a new FPS may start with a range of 3,000 to 4,500 ration card population. The field level officers will now initiate proposal of new FPS vacancy or merger of ration card by rationalization. Now, the relevant guidelines, kindly mark. The relevant guidelines stand modified to the extent as mentioned above. However, other criteria of the said guidelines will remain the same. So, first paragraph of 3rd September 29 has been modified. Now, my lord, I am just arguing for the government's sake. This order has been issued by whom? Kindly see at the top. Directorate of District Distribution, Procurement and Supply. Director is not the state, madam. He cannot modify the order of the Food and Supply Department. Now, kindly come to page 22.
Kindly, may I interrupt for a
Last
paragraph?
I am coming. I shall come. Page 22. This order was issued by the government Kindly come to page 22, my lord. Government of West Bengal, Food and Supply Department, 11. So this order was issued by the government, not by the secretary himself. It was a policy decision of the government. And this is a decision of the director with approval of the secretary. No, I ask myself whether the secretary himself is the government or the department. He is the head of the department. Can he take a policy decision himself, or can he mere approval by the secretary to the proposal of the director can be a policy decision? I shall come to it, my lord, that one. Therefore, anyway, my lord, at this juncture, I am not going in this way at motion stage, because it will have to be dealt with in judgment. Now, my second circular is 5,000 ration cards. Now, even if I rely upon this circular of 5,000 ration cards, and my ration cards are dealing to the tune of 3,000, then, my lord, I will be left with 3,650 ration cards only, which is below 5,000. And according to the present circular, which is also under challenge, my lord, I am entitled to keep 5,000 ration cards. So what I am praying for, my lord, at this stage, that let the vacancy be processed, but my ration cards should not be dealing below 5,000 ration cards. That is the prayer direction. Who I have prayed for direction, your lordship kindly see page 12, prayer D. Direction directing the respondent authorities and each of them to allow the petitioner to continue with his existing number of ration cards. To keep the balance, my lord, at present, I cannot open my mouth wide. Then to pray before lordship, my lord, to relying upon the circular, which is also bad, according to my submission, my lord. My ration cards cannot be less than 5,000. And if this vacancy is allowed to continue, my lord, then my population will be 3,650 ration cards only.
Okay.
This point, what he has, my learned friend has taken, that director is not a part of the government, principal secretary is not. How these things come into? Do I just take up a pen and pass an order and circulate it? No, this is not the process. There is a process. Whenever such notifications are carried out, there is a policy decision. There is a process which takes place. Some grievances are put forward, then a note is prepared, it is given at the highest level, a meeting is held, a cabinet meeting is held, then a note is prepared, it takes approval of the cabinet, and then these orders come out. So just saying that this is director is not a part of the government, principal secretary cannot pass this order, no.
My lord will kindly record his submission and let them file a report to this effect, whether it has the cabinet approval or not.
Under the pen of the principal secretary, then who is, I'm asking a question to myself, if a department is being run under the able guidance of a principal secretary, and he says that he is not the government, then who is the government? I perhaps failed to understand this question and I have no answer. Definitely, certain guidelines are there, something is there. Exact process, if lordship will tell, I will give that also, how this is, because I also never had the occasion to deal with such a question. If he is very sincere and urging me to, then I will get into this also. But as of now, this is very much in existence. What prayer he is citing before your lordship, what his submissions are, his prayer portion does not have that. A, B, C, D, E, F till G. I could not come across paragraph number 9. if Lordship will see that.
He is not challenged.
Paragraph number 9.
He is not challenged 28 March 2022 notification.
Kindly seize. Paragraph 9 tabak karo to.
9 and 10.
9 and 10. Writ petition, which is before your Lordship. Nine, 10. Now seize his prayers once.
Tag to mention code. This should have cited because we did not know the event at this point.
Exceptional cases. Na?
Exceptional cases, the report is what can be used. He's not challenged. He's saying I cannot do it. I have done it. He's not challenged that particular memorandum. So many without challenging.
Paragraph 32,
21, 30.
At present, I have got the limited prayer, my lord. I have said that at motion stage, I am not going to that extent. Let her file the report or a affidavit stating that this decision has been taken by the department after considering all the aspects, what papers have been, how the decision has been.
That will be in a separate direction altogether. Then the subject matter of the writ changes. Yes. जो नहीं है वो भी बता. Okay. That I will take.
Also related in Satara.
My lord will kindly consider paragraph 11 also at that time. That.
Challenge.
क्या बोले तो?
20.
My lord, after
20, 21, 30.
No, I understand.
yes.
I understand the entire issue. The issue is that issuance of a notification by the director DDPS. He says that the existing FPS may hold less than 5,000 ration cards. What does it mean less than 5,000?
That is minimum.
Not minimum like that.
In that case,
In the earlier orders, there are some gaps. That is 5,000 to 6,500 like that. Now the director has said less than 5,000. What does it mean? 2,000? 1,000? Maybe.
That is not on the challenge here.
no,
That is the order.
that is the order.
If
That
we
is-
follow the order like that,
that is the order, your lordship.
so
but
it is
that-
the authority of the state to cut down the ration card to 50 also, less than 5,000.
but
Not the earlier orders like otherwise. 6,000 to 7,500, 5,000 to 6,000. That is the limits. Now the limits,
Lordship is trying to indicate.
I want to know the lesser limit.
Lordship,
lesser limit.
Lordship is trying to indicate that in this nothing specific is being.
Yes, nothing specific.
Lordship is trying to indicate.
Yes, nothing is specific like earlier government orders. What is the lowest limit?
May I, with the
That. Yes,
permission,
yes, yes, please go ahead.
there is a notification issued by our director DDPS. But before that, I will make a request to Lordship. What we are traveling today, with extremely bad internet. Kindly make an arrangement so that we can have access to the internet, because we are all become paperless nowadays. So without having the internet, it is difficult to find it. Anyway, coming back to the point. This is my lord. Dated accurate. Just I am getting the airdrop so that airdrop হচ্ছে না।
Suvarna only has a
Read
privilege of
one
having-
honor element.
Yes. 28/3/2023.
28 March 2023.
23. Lordship is aware of the same. Now I am kindly reading the two paragraphs. Later the above range, the retained population was modified to 5,000 to 6,500 and new vacancy was to be proposed with a range of DRS population 3,000 to 4,500.
2022 notification.
2023 notification.
No,
Lordship,
that is 22 notification.
no, I am on 23 notification.
Again,
No,
Again,
what you read, that is 2022 notification.
22 notification.
Yes.
Correct. Now coming back to the 23
23
notification.
notification. What is the latest guideline?
However, certain issue has been raised some quarters regarding the retained population and proposed population for a new vacancy which were under the active consideration of the department. Now, after due consideration of the matter, it has been decided that for the purpose of proper and complete rationalization of the existing ration card population for ensuring better service to the concerned beneficiary through PDS, a new vacancy may be proposed with a population which may be less than 3,000 and DRS population retained with existing FES may be less than 5,000. Considering the local scenario, inconveniencing of the beneficiary and the larger interest of the PDS of the locality. That is the answer which is now rolling in the mind of everyone. So,
Now, what is the lowest limit?
lowest limit it can be less than 3,000.
3,000.
No, that is the new. That is the new vacancy. Or the existing vacancy?
It can be cut around up to the 3,000. Minimal is the 3,000. It can be goes around. But
Not more
3,000.
than.
Yes,
Not more than.
So
less
you are
than
saying
3,000.
5,000 to 3,000.
Yes.
Correct.
My lord, that is an interpretation by Mr. Sengupta. But what is here?
Cards are more than 3,000. Cards are more than 3,000.
What an I will like to interrupt over here, despite my learned senior friend.
And he is not challenged his notification.
Interpretation by Mr. Sen Gupta. This is an understanding of any lawyer who is practicing law. This is not what he is specifically interpreting. If a common reading, if I am also given this, I will also be compelled to think in the terms of Mr. Sen Gupta as he has placed.
Then, my lord,
If
kindly
the
read.
lordship agrees
Kindly
with me.
read this. Kindly read this.
That apart, this is not my submission.
Yes.
It is the submission or it is the decision of the government. The government is the best person to choose and to take a decision. If there is no arbitrariness, this is not under challenge.
Not challenged.
This is not under challenge. The department would decide what is viable and what is not viable. Achi.
No, he has.
Yes, it is with me.
And then this is not under
My
challenge.
lord, will kindly read this line. I am just taking leave. For the purpose of proper and complete rationalization of existing ration card population, for ensuring better service to the concerned beneficiaries to PDS, a new vacancy may be proposed with a population which may be less than 3,000. So, a new vacancy may be for 3,000, less than 3,000, and DRC population retained with the existing may be less than 5,000. So, there are two parts: one for new vacancy, one for existing. So, if existing is less than 5,000, then up to what limit? And if it is for a new vacancy, up to what limit? No limit, no lesser limit, last limit.
And his admitted is more than 3,000 by his own submission.
Therefore, it has been, my lord, in so many cases, your lordship has also held that 5,000 ration cards should be the minimum average. According to the circular. It should not be less than 5,000, but it should be 5,000.
Okay, that's all.
My lord.
Hey, so existing may be less than 5,000. New may be more than less than 3,000.
We would just request your pray before your lordship that the last paragraph in 325, 23, that last paragraph, however, certain issues have been raised from some quarters. If lordship does not have a copy, I will
I have the
hand over,
copy.
though it is
I have
there.
the copy.
Yes, though it is there. Which were under active consideration of the department. Now, after due consideration of the matter, it has been decided that for the purpose of proper and complete rationalization of existing ration card population for ensuring better service to the concerned beneficiaries through the public distribution system. A new vacancy may be proposed with a population which may be less than 3,000, and DRC population retained with an existing FPS may be less than 5,000, considering local scenario, convenience, inconvenience of the beneficiaries, and in the larger interest of the PDS in the locality. So, in the larger interest, gives ample power to the government to decide.
And this is not under.
And this is not under a challenge. I have shown the prayer part also to your lordship, and lordship has seen it.
You can indicate.
कौन सा? ये वाला? May I hand over another judgment?
For what?
The court has.
I will give you a copy, don't worry. 20, 21 or 32 बोले थे ना?
27 is
9, 10,
9, 10.
9, 10,
बोले
20,
थे।
30.
19.
9, 10 is argument.
Paragraphs, एक copy दे दो।
Citation.
हाँ, site hand over. ASTA 2017 SCC online Cal 155182, AIR 2018 NOC 23 9 2017 3 Cal LT 201.
Is also considered in.
It is also being taken into consideration in Satara Begum also. Paragraph number 9, 10.
And here the cards were reduced less than 5,000. Court upheld that.
Yes.
Yes, 9, 10, 20, 21 and 32. 20, 21 and 32. If I would take your lordship to paragraph 20.
Yes.
We agree with such contentions of Mr. Datta that the provision of paragraph 24 of the Control Order of 2013 is applicable only when the department indicates a proceeding for violation of the conditions of the license. But in this particular case, there is no allegation against the petitioner's appellants. Rather, a policy decision has been taken in large conspectus. 21. On plain reading of the above quoted memorandum and the guidelines provided therein does not give any right to the writ petitioner / appellants to hold 5,000 ration cards. Therefore, the respondent authorities can very well delink ration cards for the MR dealer shop of the appellants as long as legal right has not been in any ways fettered. 32.
19.
And 32. The provision of paragraph 22 of Control Order 2013 and steps provided therein is completely procedural in nature, and the writ petitioner appellant herein has no vested right to challenge the procedure and the directive principle of the state policy, because the Joint Secretary FNS State of West Bengal under the policy of the government issued notification dated 27 August 2013 directing the Director DDPS for asking the respective subdivisional controller of food and supply of 3 districts of Jungle Mahal area to send proposal for creation of MR dealers for inviting application from eligible candidates. Also for MR dealer new vacancy in the Jungle Mahal area through outlets created at Jungle Mahal for distribution of ration commodities to the downtrodden class. Now paragraph 34. We find that the Joint Secretary Department of Food and Supplies under memo number this dated the 5th of July 2011 has not been challenged by the appellants. This is my prayer categorically. Whereby and whereunder the government took the policy for distribution of ration commodities to the section of the poor in the left-wing extremist affected areas of West Midnapur, Bankura and Purulia for distribution of ration commodities in some far-flung areas at 23 blocks of those districts from a new temporarily identified outlets, in addition to the existing MR dealers, as per the micro plans to be prepared by the concerned district magistrates in consonance with the discussions held in the meeting with the Chief Secretary on 4 July 2011, and in the meantime, such decision was taken to tag the ration cards of those poor class in the LWE affected areas with the existing MR dealers to facilitate the distribution of ration commodities to them. Therefore, it can safely be said that by virtue of the said notification of the government, the writ petitioners appellants cannot claim a legal right to maintain writ in the nature of mandamus. This is what exactly my submission was. Mandamus, and commanding the respondents, each of them, their servants, agents or agencies to resign cancel and or withdraw the purported memo bearing number 35843 FMR 111S3 2012 dated 2/9/13 issued by the Director DDPNS Food and Supplies Department and SMDN 13 dated 23/9/2013 issued by the Subdivisional Controller F&S Mednipur Sadar and restraining the respondent authority from engaging and or appointing anybody association group in respect of the additional outlet, special counters and distributing ration articles to their permanently tagged ration card holders, and further from giving effect and or further effect to the memo bearing Mednipur Sadar in as much as the self-help groups are being given preferential term as provided in paragraph 22 of the Controller Order 2013, and for the reasons that if government so desires, it may give such opportunity to only self-help groups or others, and especially to the socially and economically backward, including women, to carry out the objects enshrined in Article 15 of the Constitution of India. We are of the view that decision of the government cannot be faulted with, which has been taken in the larger interest of the poor public of the far-flung area of Jangal Mahal in the district of Midnapur, Bankura and Purulia. We further hold that the authority which issues grants can very well recall and resign the decision within the meaning of Section 21 of the General Clauses Act. So, two submissions. In the larger interest of public, the government can, and second, if it is not in the prayer, writ of mandamus does not lie.
Also 9 and 10.
9 and 10
Record the submission.
submissions are there. Kindly seize 9, 8, 9, 10 also. The judgment, no. If they are insisting, I have to.
They are insisting.
Yes, my learned junior friends they are the foundation of all the arguments that we make.
Okay.
Yes. I hope I have made myself sufficiently clear,
Yes.
Your Lordship. So the basic point why I said that the writ is not maintainable in its first place, I have also shown certain judgments. All the circulars of the government also have been interpreted by the single bench of our court only. Then Supreme Court has also interpreted, maybe of a different state, but the problems are the point is the same. And now this judgment, the last judgment which I relied upon, says if it does not have this prayer and in the larger interest of people, the government is well within its powers to take care of the problems and the impediments that are being created.
Okay, heard.
My lord, may I take leave, my lord? Your Lordship,
Lordship is dictating the order now only?
Yes.
Yes.
Now,
No, that's it.
I always dictate order. Right?
Yes. Then otherwise,
The motion I cannot pass any order in the chamber. Please take down. Petitioner is an existing ration dealer. He catering about 3,000 ration card holders of Keshavpur, 2,500 card holders of Begri and 1,150 cards holder of Biponpada, Bipanpara, Biponpada. It is the case of the petitioner that the concerned respondent authority has issued a vacancy notification inviting application for grant of new FPS license in respect of Keshavpur. Full stop. It is the firm contention of the petitioner that if there is if one ration card holder, a new ration card holder, if a new ration card holder was appointed in respect of Kesopur area, his 3000 ration card, his 3000 PDS would be deducted from his business and his business would be viable. So he would be economically viable. So he prayed for, no, he filed the instant writ petition seeking mandamus upon the respondent authority to cancel stroke set aside the vacancy notification dated 8 January 2025. Full stop. Next para. Learned counsels appearing on behalf of the state respondents at the motion stage has raised the point of maintainability of the instant writ petition. Full stop. It is the contention of the state authority. No, Ms. Sonal Sinha, learned additional government pleader, submits that it is the decision of the state authority to engage a new dealer for a particular area only for smooth functioning of the distribution of PDS in the locality. Full stop. He submits that the decision of the authority is decision of the authority to declare a new vacancy is covered under new decision of the state, which is reflected from a memo dated 28th of March 2023 issued by Director DDPNS Government of West Bengal. DDPNS and S and DDP and S, not NS and S. Government of West Bengal. Full stop. In support of their contentions, the state authority cited a decision of a coordinate bench of this court, coordinate bench of this court, passed in Abdul Khalik Dafadar versus State of West Bengal, within bracket WPA 12446 of 2023. Ms. Sinha further submits that the coordinate bench of this court had specifically a view that the new vacancy notification was issued in terms of vacancy order by the DDPNS dated 28 March 2023. By virtue of that said memo, the state authority is authorized to issue such vacancy notifications. The relevant portion, paragraph 8 of the said of the coordinate bench in Abdul Khalik is read as follows. বলে প্যারাগ্রাফ 8টা সেট আউট করুন। ঠিক আছে, Miss Sina also placed his reliance placed her reliance upon a decision of Honorable Apex Court reported in District Collector and another versus B. Suresh and others, reported in within bracket 2019-9 5 SCC 612. She submits that no right of a dealer was infringed or no right to trade under Article 19 within bracket 1 within bracket G of Constitution of India being affected by policy decision of a state to reduce the number of card per dealer. Paragraph 3 and 4. Paragraph 3 and 4. Hello. Set out code. Set out. Ms. Sinha has also cited a decision of Honorable of a decision bench of this court passed in Gaur Chandra Ghorai versus State of West Bengal, reported in 2017 SCC Online Cal 5182, wherein distribution wherein a decision of the state authority was under challenge when the state authority has passed a decision, passed a direction for distribution of ration articles through separate agencies in left-wing extremist affected area of Paschim Medinipur, Bankura and Purulia through different agencies by carteling ration cards from the existing ration dealers. Full stop. The division bench, after thorough deliberation, has came to opinion in the has observed came to decision has observed that the decision of the authority regarding smooth distribution of ration articles amongst those poor classes of people residing at left-wing extremist areas, affected areas, is not illegal. Paragraph 34 set out করবেন। আচ্ছা, Ms. Sinha further argued that impute new vacancy notification dated 8th of January 2025 was 8th of January 2025 was issued in terms of a decision of the state declared through the Director DDPNS on 28th of March 2023. Such issue No, such decision of the state cannot challenge in a writ petition. It further submits that the decision of the state, decision of the concerned DDPS dated 28th of March 2023 is not under challenge before this court. Thus, the instant writ petition is not maintainable. Full stop. Mr. Agarwal, learned senior counsel appearing on behalf of the petitioner, submits that the decision of the state authority is not actually under challenge in this writ petition, but only the notification, vacancy notification dated 8th January 2025 is under challenge. He submits that by virtue of the said new vacancy notification, if one ration dealer is appointed for the area Kesavpur, his business would be his number of PDS would be less than 5,000. He submits that if the decision of the authority appeared at memo dated 28th of March 2023 can truly considered, it would be appeared that the 5,000 PDSs can at least be maintained by existing ration dealer. Full stop. It has been argued on it has been argued on behalf of the state authority that by such decision, existing ration dealer may retain PDS from 3,000 to 5,000, from 3,000 to 5,000, 3,000 to 5,000. Full stop. It has been firmly argued before this court on behalf of the state authority that the state has issued such directions. State authority, that state has issued such vacancy notifications considering the local scenario, convenience and inconvenience of the beneficiaries, and it is only purely in the larger interest of the PDS in the locality. Full stop. Or the learned counsel parties. In Abdul Khalek the father, Supra, the coordinate bench of this court, a coordinate bench of this court has observed state authority while acting in terms of vacancy order dated 28th of March 2023 cannot be called in question in a writ petition. Full stop. Next para. In district collector Supra, in district collector and another within bracket Supra, it was the question before the Honorable Supreme Court that whether existing ration dealer have any right of hearing before de-tagging his ration cards by the state authority. Full stop. The Honorable Apex Court has decided that right to trade under Article 19 within bracket 1 within bracket G of the Constitution of India is not affected. Thus, the dealer has no right of hearing, right of audience, no right to audience before issuance of a policy decision by the state to reduce the number of ration cards per dealer. Full stop. In Gaurchandra Ghorai, the division bench of this court has decided a issue that in exigencies, the state government has the authority to pass such a order which can actually allow the other agencies to distribute ration articles apart from the ration dealers in a particular area. After hearing both the parties and after careful perusal of the instant writ petition, it is before the it is the grievance before this writ court by the petitioner that by declaration of new vacancy notification, his right to business has been infringed. Full stop. The state authority, the learned counsels appearing on behalf of the state authority tried to demonstrate before this court that the decision of the state authority is a policy decision for proper distribution of ration articles of the locality. So it cannot be called in question in a writ court. Called in question before a writ court. The petitioner is running the business with 3 areas, that is Keshavpur, Begri and Biponpada. Full stop. It is only the apprehension of the petitioner that by issuance of new vacancy notification, his entire PDS of Keshavpur would be detagged. Full stop. It is quite dark before this court that how many ration card of how many PDS of Keshavpur would be detagged from the existing ration dealers, that is the petitioner. Thus, at this juncture, the petitioner has approached this court only on the basis of the apprehension. Full stop. He is distributing the ration articles amongst the 6,500 ration cards of 3 villages. In for Keshavpur area, there is new vacancy notifications. Petitioners or the state authority could not demonstrate before this court how many ration cards of the petitioner would be detagged. Thus, at this juncture, I find no justification to proceed further with this writ petition. The petitioner has no right at present to ventilate his grievances before this writ court, unless and until his business has crunched by the decision of this court, I think his writ petition appears to be premature one. At this juncture, thus I hold that the decision of the authority for issuance of new vacancy notification on 8th of January 2025 cannot be put on hold.
Let there be a direction for affidavits, my lord.
मेंटेनेबिलिटी पे नहीं डिसाइड
Next probably करो.
तो क्या कितना
By virtue of decision of the honorable, by virtue of the memo dated 28th of March 2023, the state authority has decided that DRC population retained with an existing FPS may be less than 5,000. However, the said decision appears to me not similar to that of the earlier notifications, earlier decision of the state
3rd September.
passed in decision of the state while order dated 3rd of September 2021 as well as 11th of February 2022. In that orders, the retained populations had some upper limit and lower limit. In the instant notifications within bracket dated 28/3/2023, there are no some lower limit. At this juncture, I think it necessary to demonstrate the matter before the I think it necessary the matter should be decided. No, lower limit. There are no such lower limit of PDS. Can retain by existing ration dealer. Now, the issue can only be decided. The issue can only be decided on affidavits. Okay. Let the state authority be directed to file an affidavit within 4 weeks. Reply, if any, by the petitioner within 2 weeks thereafter. Let the matter go out of the list.
4 weeks. 4 weeks and 2 weeks.
2 weeks. Point of maintainability as raised by the state authority kept open to be decided at the final stage.
My lord, would it be lordship pleasure to direct not to allow me to continue with the existing dealer till such?
No such deal. No such deal.
কি করবো দেখছো না করছো
Okay,
ডিপ লোক
grateful, Your Lordship.
জলদি নেই
My lord. My lord, I'm tendering my apology to mention one matter, my lord.
Now,
My lord, in order dated 17/3 March 2025 in WPA 32184 of 2008, the name of the petitioner was wrongly recorded as GOUTM Gautam, but his name is GAUTAM. So, my lord,
correction you want. You
yes,
know,
my lord. Grateful, my lord.
call the list.
But I'm appearing for the petitioner, my lord, led by Mr. Pradip Kumar Tor, the senior advocate, my lord, appearing in the virtual mode.
Yes.
Led by the learned advocate general, he is coming. It's on the way. Now, the instant writ petition has been filed challenging the decision on the part of the respondent authorities to deduct a portion from the bills against supply of sugar by the petitioner. Now, tender was invited on behalf of West Bengal Essential Commodity Supply Corporation Limited. Now, it was supply of sugar during the festive season. Time was the essence of the contract, because since the supply was to done for a limited period during festive season, so the timeline which was incorporated in the tender document as well as in the agreement has to be strictly followed by the supplier. Now, the writ petitioner, he became the L1 in the tender process and work order was issued. Now, in the tender document, there were certain stipulations. Knowing fully well all these stipulations, the writ petitioner participated in the tender.
Okay.
Now, one of such condition in participation on the tender is that the quality of sugar has to be checked and measured by the Inspection and Quality Control Department of the state of West Bengal. And the drawing of sample for the purpose of checking of its quality, that has to be done in a particular manner. That in presence of both the sides, the sample would be drawn.
Moisture content.
Yes, that was the allegation. The petitioner supplied the quality of sugar that does not match the, which I am led by the learned advocate general. So that has to be done strictly in terms of the parameters as mentioned in the tender document.
Yes.
Now, if I may draw your lordship's attention to the tender document, I'll show only some clauses. Page 64 of the writ petition. This is the tender document. It starts from page 62.
Specification of sugar.
Yes. Specification of the sugar. The specifications are there. The supplier has to supply the goods, that is sugar, strictly in terms of this specification mentioned in the tender document. So, on the day of submission of the bid, the writ petitioner was well aware that he has to supply sugar strictly following the parameters contained in the tender document. Now, let's look the page 69, testing of sugar.
Yes.
Clause B. The testing of sugar will be done through the surveyor on pre-delivery stroke at random from the godown point of the supplier. A team of the quality control staff of Food and Supplies Department may also inspect the storage godown anywhere in West Bengal, and the supplier will be responsible for quality and great supply of the sugar at all point of sale. So, in terms of the tender document, the authority who was required to test the quality of the sugar is the Inspection and Quality Control. Now, after the petitioner became the L1, the agreement was executed between the parties. The agreement starts from page 84. Led by the learned.
First, Millard, may I congratulate your Lordship, Millard,
Thank you.
because of an administrative court's decision, Millard, nowadays, Millard, I do not attend the full court reference.
I understood. I understand.
So I have requested the Honorable Chief Justice to change the decision so that we can go back to the old system and at least I can address the full court. Now, Millard, if your Lordship may kindly take Millard page 84, which is the agreement which has been entered into by and between the petitioner and the corporation. First, kindly take Millard page number 85. We are concerned about the quality of sugar. Clause number 2A. The supplier will remain bound to supply the quality sugar to the corporation as was mentioned in the tender schedule.
Yes.
Which my learned junior has placed. He will be solely responsible to maintain the quality. If the sugar is supplied of inferior quality, then the corporation may refuse to accept it, and the loss which may be suffered by the corporation must be compensated by the supplier. The corporation shall be at liberty to draw sample at any time for testing in INQC of the Food and Supplies Department or any other government laboratory to be selected by the corporation. The supplier must supply the sugar stock as specified by the corporation in the supply order. B specification. The material should be crystalline, white, odorless, and free from dirt, iron fillings, and other extraneous matter. The required quantity should be manufactured, packed, stored, and distributed under hygiene condition as per norms of the Bureau of Indian Standard.
Yes.
Now, this is so far as the quality is concerned. Then, my lord, there is a quality assurance clause. Before that, kindly take B. 2B, under 2B, I think it should have been C at page 86 after the table.
Yes.
The supplier will be solely responsible for the quality of sugar to be supplied by them. Before commencing delivery, the supplier should assist the branch camp in charges of so-and-so to draw samples from the stacks in the godowns earmarked for delivery of sugar for analysis of its grade and quality. Then is the quality assurance clause. The bidder shall have to ensure the quality of sugar supplied in 50 kg bags, which strictly conforms to the ISS specification and FSSAI standards as per specification mentioned in Schedule 2B. In the event of any of the samples taken from the stock of sugar on arrival at a designated godown is found to be substandard on testing, the concerned supplier will be wholly responsible for that. Further, the supplier will have to immediately replace the entire stock of substandard sugar at their cost up to the FPS level. Further, in the event of any of the sugar samples out of the built-up stock in any godown found substandard on testing, in addition to replacement of the substandard stock, penalty will be imposed to the extent of the sugar stock of that particular lot batch in the following manner. First time failure, sample substandard, 10% of the cost of sugar stock. Say in case of sample of sugar found to be substandard on subsequent occasion, in the same godown, 10% of the cost of the sugar stock, and apart from imposition of such penalty, the agreement with the supplier concerned shall immediately be terminated. So, Miller, this is the agreement that was entered into by the parties. There's a quality clause, there's a quality assurance clause, which also provides for the penalty first time and subsequent. Now, Millard, these are few of the basic features. Well, my learned junior Millard has taken your lordship through page 69, I'm told.
Yes.
He has place the entire clause, my lord, at page 69, so I don't trouble your lordship, my lord, with page 69. Now, my lord, please look into, my lord, page 85 or the right pages. Yeah. Now, kindly take, my lord, page number 80. না না এটাও তো দেখিয়ে দিচ্ছি পরে তো সেটা হ্যাঁ হয়ে গেছে Now please come to, my lord, the show cause notice, the initiation of, my lord, the entire cause of action. Page 96. (12-10-2018), my lord, is the first show cause. It says subject show cause for rejection of sugar sample and rebuild up of the sugar stock at Dankuni. With reference to the so and so from sugar go down at BD casting Dankuni Hooghly has been rejected for excess moisture. You are hereby instructed to replace the substandard sugar stocks already built up at the above sugar go down immediately as per quality assurance clause of the tender, which the one which I placed. You are hereby directed to show cause why penalty should not be imposed for storing of substandard stock of sugar at the godown, which resulted in interruption in supply of sugar during the festive season, etc. Reply must be in so and so. Because this is on 12th of October 2018 in regard to the Dankuni godown. Now, please take the analytical report in support of this show cause, which is at page 98. There's a table at page 98.
Yes.
Page 98, the table, analytical report of the sugar samples. I don't trouble your lordship with the table. Please see the remarks below the table. The said stock against lab sample does not pass as plantation white sugar due to high moisture content as per IS, etc. Both the samples, original as well as duplicate, were checked. Now, my lord, they replied to this show cause notice, which is at page 99.
Yes.
Can you take the third paragraph? First is assurance, etc. Third paragraph, sir, since the sampling of the sugar was done in the late evening and especially the whole area is affected under cyclonic rain, there may be some human error. We assure your good self that the whole sugar stock free flowing and dry. Moreover, we have taken corrective measures for sampling as taken in so and so. Hope your good self will be kind enough to give us a chance, etc., to resume such and such. So, my lord, they accept, they have a ground for that, but they accept that there was moisture. Now, kindly take, me the second show cause notice, which your lordship would find, my lord, at page 126. My purpose of taking your lordship through the quality assurance clause and the penalty clause is to demonstrate that what are the difference in penalties in case of a single instance and repeated instance. Now, this is the repetition at page 126. Where the same Dankuni go down.
Yes.
First recital, my lord may skip over. Second also kindly skip over. Take the third recital. Whereas it is seen that the sugar supplied by you at Dankuni go down amounting to so and so has failed to conform to the specification so and so on inspection by the Quality Control Directorate of Food and Supplies Department. Now, according to the agreement clause referred to above, an amount of rupees so and so only has been calculated as penalty on account of quality non-conformation liable to be deducted from the bill submitted by you for DDR Howrah district. You are hereby informed the matter and also directed to state in writing within 7 days if you have anything to say contrary to the above. If no communication is received within 7 days from the issuance of this letter after deduction of penalty amount, bill in question will be released. Then, Milord, this is another notice at page 127. Milord, I skip over this for the time being. Please take page 141. But this is their reply. Now, various other show cause notices were given. Milord, they are replying together at page 141. We are really shocked. Please take the second paragraph.
Yes.
As per the above mentioned quality control failure lab report, the only reason cited for rejection of the sugar was due to high moisture in sample collected for built up stock. Now, as per IS so and so, where it is clearly stated that for purpose of deciding whether the particular requirement of this standard is complied with, the final value observed or calculated expressing the result of a test analysis shall be rounded off in accordance with IS 1960. Rules of rounding off numeric value revised. The number of significant places retained in the rounded off value should be the same as that of the specified value in this standard. Vide our trailing letters and not the list so and so, your good self were pleased by the concerns raised by us in the aforesaid letters and had passed orders for resampling of the same sugar stock as there was inherited doubt about the test result obtained in the QC failure report, which may have occurred due to erroneous sampling or testing procedures. Most importantly, vide our letter, the 3 moisture reading in the same sugar sample having wide variance of 0 to 0.07% between the highest and lowest moisture reading is highly fictitious, and even NABL accredited lab report of the same quality and branded sugar was also shared with your good self, where the test reports of moisture as well within the stipulated specification mentioned in the tender, letter dated, etc. When all the, this is very important, page 142, the first paragraph. When all the same sugar built up stock got subsequently passed by DTE of I and QC without any replacement of the original built up stock, vide their lab report dated so and so, when the sampling and testing was done with some precautionary measures and allowed it fit and passed for it for public distribution. This itself is self-satisfactory about the erroneous moisture reading in the initial test report. Now it really fails to understand the acumen of any sound mind that how can a substandard consignment without any replacement, especially in commodities like sugar, which is highly hygroscopic in nature, no amount of corrective measures as mentioned in our trailing letters dated such and such and can reduce the moisture content in the sugar in any rainy weather when the relative humidity is more than so and so. Now, the technical things are being pointed out in this letter. I not invite your lordship to go into this, but finally they accept it, but raise certain disputes in regard to the procedural aspect. But I don't read the rest of it. Now, please take page 159.
Yes.
With reference to the subject cited out, this to inform you that the penalty amount of rupees so and so for QC failure and rupees so and so for delay in stock buildup has been deducted from your bills as detailed below. you are requested to inform in writing if you have anything to say contrary to this deduction within 7 days. Otherwise, presume that nothing in the matter. Then please take me to page 160. Again, the information is that the amount has been deducted.
For delay in stock build-up
Yes. And quality.
and quality.
Right. Now, my lord may take the prayers in the writ petition. At page 54, bottom.
Yes.
Mandamus quashing the notice of penalty dated 15/1/2019. Then V is quashing the penalty notice dated 15/1/2019. So this is the subject matter of challenge before my lord today.
15 January 2019.
Yes. B is 15 January, which is at page 126. Prayer A, page 126. Prayer B, page 126. Prayer C is also 126. Prayer D, E. Yes, but the numbers are different, but of the same date. I have shown only one of them. And then prayer F is the penalty at page 159. F and G.
15 January are the notices.
Yes, so this show cause notice.
Show cause notices.
Yes. And 22nd July is, or are, the penalty notices.
159.
Yes. And then we are at prayer H, they have asked for refund of 2 crore 39, which has been deducted from their bills towards penalty. I is prayer for damage, I and J, and then Sashwata. So but these are the prayers. Now, our first objection is in regard to invocation of the jurisdiction of this court. Well, the agreement contains an arbitration clause. Please take page 89.
Yes. Arbitration.
Arbitration. In the event of any dispute arising between the parties under this agreement, any of the parties aggrieved may refer the said dispute to the managing director of the first party seeking for arbitration. And after having such a presentation from the aggrieved party, the managing director of the first party will appoint a sole arbitrator to settle the dispute according so and so, and award may be given by the arbitrator binding. Now, my first submission is, because here, the relation of the parties are guided by a contract. This contract, has an arbitration clause. I don't say that arbitration clause is an absolute bar for the writ court to entertain a writ petition. I don't say that. But the point is, your lordships have imposed or created a self-imposed restriction not to entertain writ petitions when the agreement contains an arbitration clause. Because this is a party of autonomy where the parties have chosen that if we fight with each other, we will fight before the arbitrator, whoever is the arbitrator. Now, in this situation, ordinarily the writ courts do not, entertain writ petitions. There are exceptions to that also. When on the one hand, the writ courts have put this self-imposed restriction, the writ courts have also carved out exceptions where, despite arbitration clause, writ petitions are entertained. No dispute on that.
Yes.
But the point is, in which case your lordships would exercise the discretion and find out whether a case falls within those exceptions or not. It depends upon the facts of each case. Now, the exceptions, as your lordships have carved out, one of which is, say, infraction of fundamental right. Now, please consider, whether this can be said to be an infraction of fundamental rights, because any curtailment of business rights cannot amount to infringement of Article 19(1)(g), because here one of the parties have taken recourse to a contractual clause to punish the other party in the form of penalty. Now, imposing a penalty or initiation and completion of an inquiry proceeding under the contract, my lord, in my very respectful submission, will not, or the whatever are the penalty imposed, that would not amount to infraction of any fundamental right. Because the other exception that your lordships have carved out, yes, but the other exceptions is that where the party who has acted without jurisdiction. That case has not been made out before, my lord, that X has imposed penalty, but Y is the appropriate authority. That case has not been made out.
And the virus of the act has been
And
challenged.
the virus of the act. That is also not in question.
Yes.
Therefore, my lord, this is not a case, my lord, which falls within the exceptions that your lordships have carved out to entertain a writ petition despite existence of an arbitration clause.
Yes. So, but this is my first point in regard to the alternative remedy. Yes. The second aspect of alternative remedy is that this is a case which is highly technical in nature. The court, the writ court, does not, in my very respectful submission, does not have the expertise or wherewithals to ascertain today with evidence as to whether what I am saying is correct or what they are saying is correct. Disputed questions like that.
But it is not only a disputed question, but it is a question which requires expertise.
Yes.
Which expertise and wherewithal, Millard, the writ court does not possess.
Yes.
Because your lordships have held that the court is not an expert of experts. Therefore, this matter should be left to the experts who are expert in the field, and it would require, my lord, adducing both oral and documentary evidences, because if your lordship recollects the submissions of Mr. Tarafdar, he had made submission that the report which they have given, I mean we have given, does not correspond to some report which he has gathered through employing another laboratory. Now this checking between the two reports, possibly it is not the job of the writ court. The other point which has been raised is that you see your quality is X, but I have given quality X plus 1.
Better quality.
Better quality.
And better quality was given.
Better quality, higher quality was given. And this X plus 1 is recognized in the FSSAI Act. Therefore, why take steps against me? I have given you something better. Now, whether at all it is better or not, that argument at least I cannot make. Because again, the lawyers also lack this expertise. Therefore, my lord, this is a matter which is left, which should be left better to be adjudicated in a forum where parties can assist, where parties can adduce evidence, oral, documentary, then an informal forum may adjudicate the matter after taking evidence. Now, being conscious of the law, that even disputed questions of fact can also be gone into by the Red Court. Because that disputed facts, questions of fact can be gone into, provided your lordship can, on the materials placed on record,
Can decide it.
decide a disputed question of fact. Now, this is a case where even with the records, like their records and my records, we are possibly subject to correction by the court, my lord, this cannot be adjudicated. Therefore, my lord, these are, my lord, my twofold submission or two facets of the first point of my submission, that, my lord, in view of the agreed arbitration clause and the party autonomy forum,
Yes.
and because of the special nature of the dispute, my lord, the matter should be relegated before the authority, I mean the arbitration forum. Judgment গুলো আছে judgment গুলো বের করেছে। My lord, I would be very respectfully submitting, my lord, this is possibly, my lord, should be my only point, because the other points which my learned friend has raised, my lord, five fold points have been raised. Number one is sufficient time was not given to reply to the show cause notice.
Yes. That is 12 is the date show cause.
Yes.
And 13 is the date to reply the show cause.
But finally he had replied, whatever it is.
Now, in the first order,
yes,
it is clear that the point of maintainability kept open.
Right. Right.
Is there.
Therefore, that's why, my lord, I have started with the maintainability point. Or, my lord, would your lordship, my lord, prefer to, because I don't have the judgments, to be very honest, my lord, on the alternative remedy point, would your lordship prefer to hear me on another day and then on the alternative remedy and then proceed with the matter on merits?
It would be better to decide the matter on the point of maintainability first.
Right. But I'll be relying on a few judgments. Unfortunately, my lord, I have, it's my mistake. I have judgments are with me, but I could not communicate it to my learned junior to bring those judgments. Then kindly, my lord, give me 15-20 minutes on another day. Just I'll place the judgments. Your lordship hears decides the maintainability. If your lordship decides against me, my lord,
Yes, yes.
I'll make
Very,
submission.
very.
Because on merits, my lord, I'll not take more than 10-15 minutes.
Okay, please take down.
ওটা কত নম্বরে?
During the course of the movement, learned GP, no, learned Learned Advocate General has argued on the point of maintainability of the instant writ petition. It is the contention of Learned Advocate General that there is a arbitration there are existence of an agreement between the parties, and the agreement contain arbitration clause. When there is an alternative remedy, the writ court cannot proceed to decide the technical disputed question of fact. However, on the point of maintainability, Let the matter be heard on the point of maintainability.
No, এটা না। Milord, if your lordship's business permit, Milord, can it be on next Monday at 2 o'clock? Next Monday, of course, Milord, we'll be having our monthly list.
May 5 কি আছে? Fifth of May. Matter has already been paid. তারপরে 13 তারিখ দেখুন তো, 13 তারিখ 13 or 19 13 তারিখ 13th 13th of May. In the 5th, I have 2 matters fixed already.
Right. But 13th,
Because since 18th, vacations will go on.
would it be on Wednesday, Milord, 7th?
7th.
13th, I have no difficulty.
2 matters are there. I can fix the matter on 7th, but I do not know when it can be start. That is the difficulty. Already 2 matters are fixed.
In that case, keep it on 13th. Uncertainty থেকে লাভ নেই।
13th.
13th at 2 p.m.
13th at 2 p.m.
13th at 2 p.m.
I don't know if my learned senior can hear.
Lords, I'm having some throat problems, so that's why I could not make appearance before
So
your
it
lord.
is fixed on 13th.
At 13th, yes, my lord, yes. My lord.
Only on the point of maintainability.
Yes, yes, my lord, yes, my lord. And I convey also my best wishes for your.
Thank you. The point of maintainability was raised by your adversary.
Yes.
So he will take only 15 minutes by pressing some judgments. Thereafter, you would be
Thereafter, I'll give my reply.
you would do better
I'll
and
take yes,
okay.
yes, on the same day, we'll get it finished.
Okay.
Milord, there is another 2 p.m. matter fixed, the next one, item number 3. তাই তো? কি আছে পিটিশন আগে তুই তো
Yes. I understand. If post message.
Milord, if that matter also, Milord, can be kept on 13th.
13th.
হ্যাঁ
ট্রাই করে দিন না
বল
আপনি যবে খুশি করুন আগে
জজ হচ্ছে না,
জজ সাহেবের হচ্ছে না তো
কোর্টের ডায়েরি পারমিট হচ্ছে না আমাদের একটু আগে
this matter is concerned.
All matters, 2 matters are fixed on all the days. Since 5 to
Also filed an application on December application also but 2 days ago. Filed an application also. কবে করুন
যবে বলবে জজ সাহেবের টাইম থাকলে আমি আগে করবো কোনো অসুবিধা নেই
come on 13th.
Another matter was fixed on 13th. That is financial insurance.
ওইটা না ফেয়ার প্রাইস
ওটাও 13th ফিক্স করা আছে
ওটা বোধ হয় সকালে আছে
2 p.m.
ওটাও 2 p.m.
That matter also fixed on 13th. ওই তো অল বেঙ্গল ফেয়ার প্রাইস অফ all Bengal fair price of their sanctions. But we have challenged the virus of the contract.
Okay, it was argued.
It was
It was argued. It was placed for reply only.
Yes.
Reply on behalf of the.
13th 2 p.m.
Whether it will take time or not.
এটা থাক না
Mr. Sahara has started the argument.
But let this be also there.
Okay. Let's start the first matter. Let the matter be fixed or next matter. Let the matter be fixed. Let the matter be fixed on 13th May 2025 at 2 p.m. Item number 3.
Yes.
আইটেম নাম্বারটা দিয়ে দিস তারপরে অন্য কিছু তো অর্ডারটা আই এম গ্রেটফুল
Yes.
I'm grateful to your lordship.
Thank you.
Thanks.
Next. Number 2 টা এটা ডাকেন নি? Okay.
I am for the petitioner. Learned Advocate Mr. Ramanand Agarwala, who is appearing in this matter, is not prepared today. Kindly, I'm praying for.
Which
kindly
matter?
make it not this week.
Allot this matter pertains to ration cards which were not existed around it. Those the petitioner was
You take the mic, I cannot hear you.
petitioner supplying ration articles with regard to those cards also. So inquiry has been done. Probably this matter pleadings are complete. My lord. Now is ready for hearing.
So
In that case, my lord, if they are asking for not this week, my lord, Monday, my lord,
Monday 2 p.m. I cannot fix.
then as,
Monday
as
2
your
p.m.
lordship please.
2 p.m. cannot fix the since next Monday 5 to 8. I have already fixed 2 matters all the day for 2 p.m.
I leave it to your lordship's convenience.
14th তারিখ দেখুন 14th. Is there any interim order?
My lord, last order.
আছে 15 বৃহস্পতিবার হবে না 19
I believe there is an interim order, my lord, but I have to check, my lord.
19th Monday.
Grateful, lordship.
An accommodation is sought for on behalf of the petitioner. Let the matter appear in the list on 19th of May 2025 under the same heading at 2 p.m. Next.
Item number 4.
Yeah, please, Your Lordship. My lord, I am for the petitioner before Lordship. There's an ad interim order, my lord, that is still existing till 30th of this month. There's a direct.
This matter probably, my lord, we are supposed to file the report, my lord, by way of an application.
Yes.
My lord.
Yes.
I need extension of time to file the report, my lord.
My lord, let it be extended, my lord, till the disposal of the application.
My lord, kindly.
So what time you want? How many time you
2
want?
weeks, my lord. 2 weeks, my lord.
2 weeks.
2 weeks, my lord.
Learned counsel appearing on behalf of the state respondent seeks time to file a file report. Having heard the learned counsel, the time for filing the report in the form of affidavit be further extended till further 2 weeks from date. Next para it appears that the interim order passed by this court is going to expire on 30th of April 2025. Having heard the learned counsel for the petitioner, let the interim order passed by this court is further extended till 23rd of May 2025 or until further order, whichever is earlier. List the matter under the same heading on 20th of May at 2 p.m.
Oblige, Your Lordship.
Lordship, congratulations.
Thank you.
Lordship, may I permit to mention a matter? Lordship, kindly, item number 2, kindly fixed any date before 7.
Before 7, not possible. I have already fixed the date. Next.
Well, 9 is other side not there. I just formulate 4 points why I am for your lordship and why I am opposing the same. This is the tagging of the same. Detagging of the ration card. Now the 4 questions I have formulated myself, Milord. First is whether that is covered by the directive principle of the state or not. Number 1. Number 2, the preamble of the act by detagging is being frustrated or not. This is the second question. Third, if I allow to go the same without detagging the same, whether am I not encouraging the Article 14 to say go by or not? Last.
Yes.
Article 19(1)(g) prevailing over the Article 21 or not? These 4 questions I have to answer before your lordship.
Article 19(1)(g) whether prevail over Article 21.
1, yes or not. Because if I start reading from directive principle of the state, then directive principle of the states, it empowers us to supply the food grains to the every commodity. I just indicate 2-3 lines, I will not take much time of your lordship. 2-3 lines.
No, let Mr. Huda come. Otherwise,
it is a futile exercise because I don't think it is.
Yes.
তাহলে সবগুলো ম্যাটারই বলে দিই। There are branch of matter. Lordship kindly keeps it one day so that I can.
1911.
9. I just indicate
the same issue. I understand.
Just give me a
same issue. 9, 10, 11 are the 3 matters. I posted the matter for hearing.
Correct, Milord. Correct.
Hearing of the state regarding the maintainability of the.
Milord, yes, the maintainability and the fundamental right of the principle or the petitioner has been affected or not. That has to be tested by this court.
Very well. Let them come. So 3 matters or other matters are there?
I just indicate, Milord, there are 3-4 matters. I just 3, 7. Give me a moment. Item number 28 is also here. 31, 38, 39, 76.
Item number 9, 10, 11 and 38.
39.
38, 39.
31 bole de. 31 ta bole de. 31, 28 is also there. 39, 76, 79. But up to this, I think you will,
76,
79. If any of the matter is not related to the others, Milord, kindly post it in other day, Milord. I will come and argue the matter.
Come on tomorrow then.
Yes.
Come on tomorrow then. All the matters I can fix with the 7, 9, 8 and 10 under mention matter.
11.
9, 10 and 11.
31 to what? 31 would not be there. 31 টা পরে করি না, not in the same category, কিন্তু আমি আজকে না করে অন্য দিন করি, সেটাই বলছি। ঠিক আছে।
So 4 matters, 38, 39, 76 and 79.
And that apart, item number 9 is also there, which
9, 10 and 11.
10. অসুবিধা নেই তো?
Okay. Item number 9, 10, 11 are 38, 39, 76 and 79. All mention matters. Mr. Huda is there.
Will appear tomorrow, Milord?
No, not tomorrow. করছি না আজকে, তুই নেই আর করছি না। Since you are not here, I am not arguing the matter today. অনেকক্ষণ চলবে কিন্তু 4:30 অবধি চলবে। ছেড়ে দে, আজকে আর করবো না। অলরেডি বলে দিবি। নেক্সট উইকে
Tomorrow. I am fixing tomorrow today.
There's a matter before court number 1, my lord. That we brought one for example.
Day after tomorrow.
Day after my lordship is fixed a lot of matters.
Day after tomorrow is uncertain day. No, tomorrow I fix it tomorrow.
Today itself.
Today, as you are not there, I am just starting hearing. Thereafter, I stop them because you are not there. No, they want to post some others matters with that.
No, no, এটা those matters which I'm sure my lord they're talking about.
38, 39, 76 and 79 has to be listed along with those matters.
But 2013 no sure.
Yes, all matters are there. They want to argue on the point of law in this matter. However, maybe let them
What they have a right
come on
to
tomorrow. Come on tomorrow.
My lord.
Come on tomorrow under the mention matter. Your matter, I understand. The these 5 matters will be taken up later. You do the matter and
Then lordship will kindly excuse if I'm not there.
yes, no issue. You send
If
someone,
somebody
you
junior
send
sir,
someone,
will
your
give it,
junior.
take the notes. Yes, yes.
I will take these matters later. Okay, after 12. There are some other mentioned matters also. If you are not there, I can fix this matter at 12:30. On this, you
As it please.
come on. Okay,
Tomorrow.
Item number 9, 10, 11. Order করতে হবে না 38, 39, 76, 75 fix করুন 12:30. 12:30. Tomorrow 12:30. Tomorrow 12:30. 76, 79. 76, 79.
Other 2 items are concerned, my lord. I am enjoying interim order, my lord, till the maintainability is decided. Only for my lord, 1 item, I am not enjoying the similar interim orders, my lord. If your lordship will kindly consider that. But your lordship has kept it tomorrow.
Yes, tomorrow.
But license has been issued, my lord, after
Okay.
the order license was issued. So lordship will kindly consider this tomorrow. That's
Tomorrow.
all.
No, in item number 9, 10 and 11,
Yes.
you have the interim order.
I have the only item number 9 I do not have.
11, there is no interim order. 10, 11, there is no interim order. You are saying there is an interim order? No, I will find it.
There is an interim order, my lord. There is.
Okay.
But may I read the order?
No, it is not required. What you want? Tomorrow it will be fixed.
I am protected so far as 10, 11 is concerned. Only for 9, my lord, the license has been issued. Just issued, my lord.
No, that is the all
but-
separate issue.
Yes, since
Point of
lordship is-
law is involved here.
Since your lordship
So
is
I have to
taking up
decide
the
the
matter
point of
tomorrow, I have no issues, my lord.
Okay.
Till tomorrow I can wait.
Tomorrow. Call the 12, item number 12. কটা কোন? কোনটা এটা? হ্যাঁ? হ্যাঁ 9 সেখানে বললাম 12:30। হুম। Change? কোন নামটা? রাম রাজ পণ্ডিত। This matter appears for correction. In the order dated 24th of January 2025, the name of the, no, the cause title of the matter should be corrected as Sushma Raj Pandit and others versus Shokon Kumar Pradhan and others. Within inverted commas থাকবে instead Sri Ram Raj Pandit and others versus Srimati Shankari Pradhan. এইটাই কাটবে, এইটা হবে। Next. Okay. This matter appears for correction in order dated 28th March 2025. In the eighth paragraph, within bracket in page 12 should be read as within inverted comma in page 11. Page. Next paragraph. In the 11th paragraph of the said order, the term within inverted comma, double inverted comma of paragraph 29 should be inserted in between at the third line, inverted comma and our inverted comma শুরু করো the date of execution of Orponnama deed. ঠিক আছে। Next.
Lordship, I am appearing for the petitioner. I'm
Yes.
filing the new wakalatnama.
You file it in the department.
Department. Yes, Your Lordship. The matter is about the petitioner is a fair price shop dealer and he has been rendering his service since 1995. Joint inspection was held in his shop on 12th April 2022. Upon that inspection, a so-cause notice has been sent to the petitioner and his license has been suspended. But the report of such joint inspection has not been served to the petitioner herein.
So why you are before this court? What you want? What is your prayer?
The Lordship, my prayer is that whatever the appellate authority, second appellate authority has upheld the decision of the rationing officer that the suspension of the license of the petitioner is valid. We are challenging that on the ground that it is violating not servicing the joint inspection report to the petitioner is violating the principle of natural justice. On the last occasion, your lordship has pleased to order the respondent authorities to file a report. I believe that has not been filed, as we haven't received any of the copies of such report.
So how it is appearing today?
Sir, the matter has been mentioned before your lordship and
For what? Who is for the appearing for the state? Miss Sonal Sinha.
Miss Sonal Singh and Mr. Abhishek Prasad. Lordship, the petitioner is a senior citizen of 60 years old. So he is the only bread earner of his family.
Very. Please take down. This matter appear under heading to be mentioned. Petitioner mentioned this matter for listing. None appears on behalf of the respondent authority. Petitioner is directed to serve notice upon the learned counsels appearing on behalf of the state. Let the matter appear in the list under the same heading on 14th of May. Next.
Item number
I'm
15 for the petitioner, my lord.
I'm appearing for state, my lord, item number 16.
15.
Led by Mrs. Sagnam.
My lord. Correction.
For correction, my
15 to 20, all matters are there for correction.
online.
Our video has stalled. Here. On now. Item number 16.
My lord, I'm appearing for the state, my lord. My lord, I'm appearing for the
Just state
state.
your face. You are
My lord,
otherwise
I'm appearing for the state, my lord.
I cannot visualize you. Yes. কি হয়েছে নাম কি আছে নামগুলো দেয়নি হ্যাঁ কি নাম হবে for the state. Yes.
Where appeared, my lord, on 7th.
My lord, I'm appearing for the state, my lord. I have my junior is there, my lord. On
Video,
dated
you correct your video.
My lord.
Not by that way.
My lord.
Not included, my lord, our name.
My lord,
7th April.
You must have to be given your name there. You have not given no.
my lord, our name is
I have mentioned the matter that the Mr. Shishano Bandyopadhyay and Ritesh Kumar Ganguly was appearing.
Item number 16.
Who are appearing in the item number 15.
my lord regarding WP 661725, my lord. It is assigned with Ms. Shabnam Devardhan, Junior Government Advocate, and Ms. Kakuli Noshkar, my lord. And all the matters are tagged, my lord, 15 to 21.
You just correct your video. Why you are looking like that?
My lord, now it's okay, my lord.
No, not okay. Please take down.
My lord, can you, my lord, on that 7th, our name's not appearing, my lord. Shabnam Devardhan,
I have
Junior
heard. I have
Government
heard. You
Advocate.
don't have to argue further.
Grateful, my lord. And heartiest
This matter
congratulations to
appears
my
for
lord, my
correction.
lord.
This matter appears for correction. In the list of representation by the learned counsel appearing for the state in the matter of WPA 6617/2025. The name of learned advocate Miss Shabnam De Burman
Bordon, my lord.
Bordhon,
Junior Government Advocate, my lord.
Junior Government Advocate, and
Grateful, my lord.
Kakoli Noskor Advocate would be inserted in place of Mr. Shishano Bandyopadhyay
My lord.
and Mr. Ritesh Kumar Ganguly.
No, my lord.
Regarding 6617, my lord, writ petition, that is assigned to us. That writ petition is assigned to us. They have been assigned Shudip Sharkar, 6533. Their names will be there. But my lord, our names not appearing on 7/2/24. That is incorporated or inserted, my lord, or included.
Should be inserted in place of.
Not in place
And
of,
Mr.
just inserted, incorporated.
They are already there.
Yes, they are in another writ petition. That is Shudip
Maybe they are
Sharkar.
in another writ petition. Whatever you
Yes, but not in our writ petition.
কত নম্বর item?
66. Item now with item number 16, my lord. 6617. Item number 16.
কি আসবে একই তাহলে
Our name to be included or
item number
incorporated.
ওটা কি বলেছি বলো
Item number 16.
না in item number কি বলেছি প্রথমে in the list in the list of representation in order dated action correction করো সব action করতে হবে হ্যাঁ না আলাদা হবে না কি সঙ্গে একটাই অর্ডার হয়ে যাবে তুমি কি লিখেছো বলো and WPA 6691 হয়েছে in order dated 7/4/2025 হয়েছে তারপর কি বলেছি হ্যাঁ ঠিক আছে সেম আছে কাগজগুলো নাও না কেন নিলে এসব ঝামেলা করে না
My lord, one indulgence, my lord. Heartiest congratulations to your lordship.
Thank you.
For today's.
Thank you.
And my lord, your lordship will be elevated to Supreme Court also in future.
You are not like that. Your alignment is otherwise. Just fix your mobile correctly. Okay, next matter.
Gratefully, Your Lordship, my Lord. Regarding writ petition 6617, my Lord.
Next.
Gratefully, Your Lordship.
21, my lord, Mr. Ramesh Dhara is for petitioner. He is on his legs in courtroom number 11. My lord, kindly make it on Wednesday.
Why Wednesday?
My lord, tomorrow he
It's
will
for
not be available.
non-prosecution.
I am not holding the brief.
Okay,
my
okay,
lord.
okay. Day after tomorrow.
I'm grateful.
Next.
Madam, time for the writ petitioner, my lord. We have find a
My lord, I was the added respondent, lordship. So, my lord, in the writ petition, my lord, affidavits have been exchanged. In the meantime, my lord, after filing of the affidavit in opposition, my lord, there was an RTA application by my client, and certain replies we have received. That reply, my lord, has completely changed the situation, my lord. Why, my lord? The principal grievance of the my lord, writ petitioner in the writ petition was that my cards have been delinked.
Yes.
Which was attached with my client, who was a new EMA dealer. But the RTA reply says none of the cards from the petitioner was delinked.
Where is the RTA reply?
So, my lord, may I respectfully invite your lordship, my lord, to my lord, page, my lord, 22 of the my lord application. This was my my lord application, my lord. Queries were, my lord, kindly sees, my lord. How many ration cards have been issued under Raghopur? This is the place which is involved. Najrul Islam is a license holder. His license number so and so. How many ration card goes to Raghopur from Najrul? He is the petitioner. Na? So Najrul is the writ petitioner before your lordship. Kindly see the answer, my lord, given to question number B. Reply is, my lord, at page
Najrul is the petitioner here,
lordship.
who apprehend that his car has been detected
Lordship.
and attached tagged with your ration.
Lordship.
So this is the grievance here.
Lordship.
And
I
you
shall take that particular paragraph of the writ petition also. I shall show to your lordship.
No, what is the answer?
So kindly see the answer given, my lord, to that question at page, my lord, 24. If I may respectfully invite your lordship to page, my lord, 24, my lord. Kindly see answer to question B. No DRCs have been pulled for the vacancy ID from APS Najrul Islam. The specific query.
no, no, that is number of DRCs.
Number of DRCs. All right. Number of DRCs have been pulled from the vacancy ID from Najrul Islam. So, my lord, this is the, my lord, reply. Your lordship, if I may respectfully invite your lordship, paragraph 16. Why Gopal? Gopal is how it is related to this. All right. We are, who are we?
There was no DRC pulled. That is the question number D. Answer number D. How many?
There was no DRC pulled from the APA Najrul Islam. So Najrul Islam, the repetition of your lordship, is in no way affected. Now, may I respectfully invite your lordship to my paragraph, my lord, 16 to 19 of this interlocutory application, my lord. Wait, it's very difficult. Paragraph 16 to 19, my lord, I have stated, my lord. So, as on date, my lord, Najrul under no circumstances can be regarded as an aggrieved person. And, my lord, he does not have any cause of action. My lord, may I respectfully invite your lordship, my lord, to the writ petition once. Writ petition, my lord. May I respectfully invite your Lordship, my lord, to paragraph 5.
Yes.
Kindly see the averment, my lord. The petitioner is presently catering 3,250 ration card holders of Bikhanpur and 1,000 card holders of Raghavpur. So this is the place Raghavpur you are concerned with. And if the said ration cards are delinked from the petitioner's dealership, the petitioner will be left out with only 2,850 ration cards, which is not viable for any dealership. This is in the affidavit your lordship kindly sees. He says it is within his knowledge. So, my lord, reply to the RTI is clear that none of the, my lord, cards were delinked, my lord, from this gentleman. Whatever cards were delinked, my lord, were delinked from Gopal. It is some other, my lord, dealership. Kindly see, he says this is within his knowledge.
Bikhanpur.
Bikhanpur is another area, but we are concerned with Raghavpur.
Raghavpur.
So he says 1,000 card holders of Raghavpur were delinked from him to me, who is a new licensee.
So new vacancy declaration, where is the vacancy declaration?
Vacancy declaration, my lord.
That is Bikhanpur, not Raghavpur.
No, we are concerned with Raghavpur.
He says that the Bikhanpur is the issue.
No, he says kindly see second and 1,000 card holder of Raghavpur. Paragraph 5 of the writ petition, my lord. 3,250 ration card of Bikhanpur and 1,000 card holder of Raghavpur, Kalitola.
No,
We are concerned with Raghavpur,
you read page 23.
Page 23 of the, my lord, writ petition. Bikhanpur vacancy এর উপর অভিযোগপত্র। রাঘবপুর কালীতলায় নতুন রেশন দোকান হলে কালীতলায় প্রায় 1,000টি কার্ড সংখ্যা কমে আমার দোকানে প্রায় 1,600 হয়ে যাবে।
যাতে আমার কোনো আপত্তি নাই।
কিন্তু ভিকনপুরে নতুন রেশন দোকান হলে ভিকনপুরের কার্ড সংখ্যা 3250 কমে আমার দোকানে 2850 তে চলে আসবে।
So Vikanpur is the issue here, not the Raghavpur.
No, Vikanpur is already somebody is there.
So you are not affected.
No,
my lord, whatever
that is
it is,
6, my lord. We allow me to place my application. My dealership.
There is an order of this honorable court, my lord. Kindly come to page 18 of the application, my lord.
I'm showing gradually. I want. That is my prayer.
Kindly come to page 18, my lord. My lord, there is no scope for interference right now, my lord. Kindly come to page 20.
Affidavit in this matter?
Yes, my lord. My lord, kindly come to page 18, 20, my lord.
No, let Mr. Galib complete. Let Mr. Galib complete.
But there is no scope, my lord. Since, my lord, the honorable court has directed, my lord, no license shall be issued to the selected candidate till the disposal of the instant writ petition. So, my lord, whatever his grievances are now, my lord, and my lord, we have challenged 2013 control order, my lord. That is, my lord, before the honorable division bench, my lord, and it is, my lord, today, my lord.
What is your prayer in this application?
My lord, kindly sees the prayer. The prayer clause starts at, my lord, page 10. Direction to bring on record the application under section 6, dated so and so, and the memo dated so and so on record. Because I have got the reply after filing of the opposition to the writ application. That is, I want to bring this on record. That is one. 2, my lord, an appropriate direction so as to clarify, modify the order dated 22nd August 2023 passed by a coordinate bench of this honorable court in WPA number 20174 of 2023. That is the order, my lord, at page, my lord, 18. What is the order, my lord? At page 18, my lord, that is an order passed by an honorable coordinate in the same matter. Kindly sees, my lord, page 20 of the order. That is the ordering portion, the last but one paragraph.
Yes.
It says, in the meantime, there shall be an order of status quo in respect of dealership business of the petitioner till the disposal of the appeal pending before the Honorable Chief Justice or until further order whichever is earlier.
So what you
Order
want to
status quo.
modification?
Status quo in respect of dealership business of the petitioner.
So what modification you want?
Modification to the effect, since none of the ration cards were delinked, my lord, evident from the reply from the petitioner to me, so his dealership business is in no way getting affected.
No, he filed this writ petition for Vacancy, not your.
No, that was for 6. There were two added respondents. One is 5, one is 6. So added respondent number 5 is before your lordship with this interlocutory application. 5 is for Raghopur.
Let me understand your submissions. So you say that no ration card has been dealing from your go down
From
your
his.
FPS to the petitioner. So why you affected?
No, he says in his writ petition that his cards, 1000 in number, have been delinked and have been given to me for Raghopur.
So it was
And
not
for
given to anyone.
Now reply says
Not delinked. Not delinked.
Not delinked. Reply says not delinked. So
How he is affected and how you are affected.
No, that is why, since his foundation of the writ petition was that his card is getting delinked and given to me. So it has no cause of action. So this status quo order with regard to his business, in my humble understanding, requires a clarification, because his business is not getting hampered because none of his cards have been dealing to me.
So let your reply at page 24 be taken on record. Let the
24.
state to file a report on that point. The reply of the RT, you take an instruction. You take instruction.
This matter, my lord, this is similar to, my lord, we have challenged the control order, 2013 control order. All matters are, my lord, are pending. My lord, your lordship knows very well, my lord, it is pending.
Take a report.
In my respectful reply to my learned friend's argument that we are stuck by the division bench order.
Many of them are like.
Very good. Division bench order is with a rider that those whose licenses have been given prior to the passing of this division bench will not be getting affected. So my license ipso facto on record was issued, my lord, much prior to the passing of the my lord division bench order. Lordship kindly recollects that was my lord contention before your lordship. Humbly I submitted. But since my learned friend's contention was no, my cards are getting delinked to you, so my business will get hampered. So as on date, since the reply from the authority comes that none of the cards from you are getting delinked to me, so you have no cause of action today.
Very well. I understand your submission. Please take down. Can 3 of 2025. This is an application filed by the respondent number 5.
Lordship. Added respondent number 5.
Added respondent filed by the added respondent number 5. Full stop. It is the contention of the respondent number 5 that in terms of a reply of application under RTI Act 2005 dated 4th of March 2025, it has come to knowledge to the respondent that no DRC pulled from FPS of petitioner for the vacancy ID at Raghavpur. Full stop. The said reply placed at page 24 of the application being Can 3 of 2025. To decide the issue raised in
The applicant is only concerned with Raghavpur.
Can 3 of 2025, it appears that the state respondent are required to submit a report, short report on that point. Let the short report be placed within 2 weeks. Release the matter on 20th of May. Under the same hearing. Under the
And kindly keep it after vacation, my lord. My lord.
May it be at 2
since, my
p.m.
lord,
Lordship.
In this matter, my lord, Mr. Agarwal is appearing, my lord. He will not be available, my lord, on 20th.
Let them submit a report. You see the
Let them-
report.
Let
If you
keep
want
the
to
matter
file,
after vacation.
I given them only 2 weeks accommodation.
May it be at 2 p.m. Lordship. At 2 on the said date, Lordship.
It will appearing under heading to be mentioned. That means before 2 p.m. Okay. Submit a report.
Lordship, heartiest congratulations.
Thank you. Khalif. I know you are happy. Okay. Yes. Any issue is there? Yes. Any your matter is there? Yes. Item 24. This is the second appeal and the applications. So it was special assigned, I understand, but the who is appearing for the other side? You have served. I want to fix a date for hearing. Otherwise, it's not possible to take up this matter today.
Not today. 10:30 I'll indicate them any day before this period of vacation because they were on reply.
Yes, they are on reply. I know.
Kindly keeps it
This is a partner matter. I understand.
Kindly keeps it to be mentioned tomorrow 10:30. I will just communicate them so that the dates can be fixed and
Okay, very well. Tomorrow. The matter is of tomorrow.
great.
কবে রাখলেন এটা?